21.
Tomorrow.
Tomorrow call देंगे.
Second term to 21. Last time also I had a memo. Had a memo. The office is not listing that letters.
Second appeal of the year, fresh admission.
Transmitter matter. Transmitter.
Yes.
Transmitter matter. Transmitter.
What matter?
It is confidential challenging the confidential judgment.
Yes. Yes.
Challenging the confidential judgment.
Second appeal.
Nothing challenging the judgment of the Learned Educational Tribunal.
Yeah, that is not in my assignment.
2011 matter.
No, not my assignment. It's an FAO. FAO writ application. Writ application. How are you challenging the order of the tribunal?
Lordship, challenging the illegal appointment of Bank Mitra of Digo Point Block.
Yes.
Already given.
Yes, regarding selection of Anganwadi worker, the selection is going to be conducted tomorrow. Today I have filed the case.
Nothing can be done. Dear Lord, kindly pick
37, it is a fresh admission.
one, only one,
Yes, Lordship, to 28.
only one.
My lord, may pardon my lord. When it extension of time. The surrender date at 27
Yes.
today.
Fresh admission.
No.
Second fresh admission. तो 5टा day salary memo. गुट्टे भी आसने.
Only.
24/7 last day.
Yes.
I may be pardoned to make
I
I may be pardoned to make a mention, my lord.
2003 रो pending ଅଛି madam.
I may
लोगों ने ये
I may pardon to make a mention, my lord. Petitioner are in jail custody after surrendering the before the trial court on 7/8/24.
Pardon to mention, my lord. Second appeal matter, 2003 matter, my lord. And substitution has been not been regularized.
Lord, second appeal extension of interim order due to change of assignment, it's not being listed. So I have given memo last
Where is the
week.
memo?
I have given. Can it be? Can it be?
I'll go through each memo. I will pass out.
But item number 33 days supplementary.
33. Yes.
Due to personal difficulty.
I am for the petition, ma'am. On behalf of Mr. Praharaj.
What do you want?
Next week, ma'am. Column.
Item 33. Let's just matter next week as paid for.
Item 45 may be taken up next week.
Item 45. Let's just matter next week as paid for.
I beg your pardon to mention, my lord. I'm appearing through VC, my lords.
Yes.
My lords, it is with respect to bail application number 5616 of 2024, my lords. This bail application was filed in the month of May 2024 and it was placed before His Lordship Justice A.K. Mahapatra. It was supposed to be listed this week, my lords, for order. But due to change in assignment, it is now destined to be placed before your Lordship, my lords. So
Has it been specifically assigned to this bench by the chief justice?
After all matters prior to July 2024, all bail matters, it has to be placed before your Lordship, my lords.
No, there is no such.
As per the assignment dated 28th of this month, my lords, 28th of August 2024.
Sashikanta Mishra. Sorry. SS Mishra. Wrongly.
Oh, this must be before Justice SS Mishra, Mr. Shivashankar Mishra. I am a different Mishra.
My lords, I know you very well, my
No, that
lords.
is second appeal of
I'm
the
sorry,
year.
my lords. I'm sorry.
All right.
That one second appeal of the year 2017. That there is a stay on the execution proceeding. It is for recovery of possession. The Lordship asked the order for hearing and the date was fixed. Thereafter, it is not being listed.
Yes, item 1. Supplementary list item number.
Transport petition, my lord. From my lord, Mayurbhanj to Jharsuguda, my lord.
Who are you? You are the wife.
Wife, I am the wife, my lord. Husband filed for
All right.
decree of
Take
divorce.
notice. Place this matter on 3rd October. 3rd October.
Stay. File file.
Are you
I number, my lord, 257 of 2024.
It's a noting কিন্তু I is not there on record. Oh, I arrest record.
257 of 2024.
Item number 2. Yes, item 2.
Petitioner is a wife. She
Yes.
needs to transfer the civil proceeding from Bhadrak to sub-judge Balkanegit or family court judge. As she is residing at
All right.
Coilwood.
Notice. Stay.
Item number 3. Wife is here, my lord, filing this TRPC, my lord, for transfer of this CP from Judge Family Court both to Sambalpur, my lord.
Notice. Stay.
Item number 4.
May I please, your lordship.
Here, my lord, from to
What is this petition for amendment?
petition of amendment TRP টা TRP CRL হবো সেটা data nomenclature টা
It has to be re-registered over. Re-registered. Data already finished. Out number is.
সেই নম্বরটা দেখো nomenclature টা
না না নম্বরটা চেঞ্জ হবে না টিআরপি সিআরএল এর তাଙ୍କର যাହା নম্বর ଥିବ না
TRP CRL
চেঞ্জ হবে এনিওয়ে তুমি যাচ্ছ টু ভুবনেশ্বর ইউ আর দ্য হাজব্যান্ড
I am the husband and serving and suffering from mandible cancer. And other two matters. So far the CP is concerned, 498, it is pending all the way at Bhubaneswar. I am fighting out this litigation.
where have you
As
said
required,
where have you said that you are suffering from cancer
my lord, it is at Para.
all right para 7
Six,
yes all right take notice
Para 7.
notice take
Item number 5.
Yeah, please. The petitioner, the wife, husband had filed a
Baripada to Bhubaneswar
civil proceeding at Baripada.
yes
I'm staying in Malat Jaleswar.
Jaleshwar
Jaleswar. I pray Malat to be transferred to Baleswar Malat.
notice take
Item number 6.
Present application filed by the wife, transfer of divorce, application filed by the husband at Kendrapada.
at
Application filed by wife, my lord. Transfer the case from Kendrapada to Bhubaneswar.
from Kendrapada to Bhubaneswar all right
Item
date order सब 3 अक्टूबर को
Item number 7.
But may I please, your lord, my lord, here, my lord, the wife petitioner filed the case seeking transfer of the civil proceeding from the court of law and judge, family court, Jaipur, to the court of law and judge, family court, Gajpati at Targaland.
notice take
My lord.
Item number 8.
Petitioner is the wife, your lordship, seeking transfer from Balangir to Sundargarh, divorce proceeding initiated by the husband.
all right notice take
Item number 9.
It's been the third round litigation. Earlier, my lord, the 2011, I challenged the selection of the property post Anganwadi worker, the same Tabla Center. I succeeded in the appeal. Thereafter, matter tried to this court by the person who was appointed in my place, Ranjita Nayak. On my appearance and filing out writ to dismiss. Yes, thereafter, my writ to appeal dismiss also. That is, my lord, page 20. Your lordship directed that in view of dismissal of the writ of petition as well as writ of appeal, my case be considered by the ADM and the order of ADM be complied. And now, the lordship kindly page 42, paragraph 4.
just no action has been taken by this to implement the specific directions should be given upon point the sub collector Nagar to take expedient steps yes now what happened
And now, then without condition, now kindly say annexure 8 is issued by the CTPO for fresh appointment.
all right take notice
I have played first annexure 8.
the learned AGA accepts notice on behalf of all the opposite parties
Right.
I let him file a counter within 4 weeks list this matter
The 3rd October.
Huh?
3rd October.
on 3rd October IRA in the meantime no selection process shall be initiated pursuant to has it been initiated
Not initial. Only advertisement.
na 1/8 ethera thila na
Advertisement issue is there. Advertisement issue that is on 8/1.
no selection process shall be and/or finalized pursuant to the advertisement dated 1/8/2024 till the next date
Item number 10.
It's covered by Dhananjay Chand Mera.
Either. some of the appropriate correction is
I've already corrected.
Item number 11.
11, my lord. Annexure 5 is under challenge, whereas OP number 3 set aside the
why the order of
Government of
opposite
the
party number 3 on annexure
petition on the
5
ground that,
appeal number 8 shall not be
selection of
set
the
aside.
petitioner is
Nodi center and Dharnagati block.
Hello, my lord. Fact is that
So where is the appellate court's order?
appellate court's order, my lord, under annexure 5, my lord.
Yes, what are the facts?
Facts is that the petitioner and opposite party number 2 were the applicants in person to the advertisement by the annexure 1. Both applied.
applied and the petitioner is selected for the post of Anganwadi worker in the Anganwadi center. Thereafter, the opposite part number 7 challenged the appointment of the White Annexure 3. First he had prepared one appeal, which is by the ADM. After disposal, she filed one writ application before this Honorable Court. This Honorable Court again remitted back the matter to the ADM for decision. Then after hearing White Annexure 5, the ADM set aside the order that the proper process has not been maintained, and hence the appointment of the petitioner is not proper, and fresh advertisement be published, and again selection to be made in that center. My submission is that the advertisement that secures more marks, it should be selected. I am having the qualification, higher qualification. In higher qualification, I secure 5% and experience certificate 5%, 10%, and matriculation 45%. So I secured 55%, whereas the opposite part number 7 is concerned, she has secured 52%, which is not taken into consideration. So hence, under Annexure 6, I applied for the entire documents which I had applied at the time of selection. That my experience.
No. He holds the ADM. Finally holds that in view of the fact that this court is inclined to hold that the selection process of Anganwadi worker or Bina Panisari is erroneous due to wrong calculation of weightage during preparation of merit list, and it is against the guidelines of the selection of Anganwadi worker. So, what wrong is he referring to?
What wrong is that I am having the higher qualification. So accordingly, I secured 55% marks, whereas the opposite part number 7, she has secured 52% mark. The certificate which I had submitted at the time of applying my candidature for selection, that is, and which includes experience certificate, that is page 47, which is not taken into consideration. That is, it is also obtained under RTI. That adds 5% marks. And since
besides, the selection committee has wrongly calculated full marks of HSC examination of the respondent number 6. You are the respondent number 6.
Yes.
In that application.
In that application.
As 700, for which her percentage of marks was calculated as 53% instead of 45%. Adding further 5% for higher education, the total marks of the respondent should have been 50% instead of 58%.
That is what, my lord, it has been submitted by the CDPO during the selection process, which
700 ଜାଗାରେ ସେ ତାକୁ 600 ମାର୍କ କରିକି କରିଦେଲା ଏତିକି ତାପରେ ଯେତେବେଳେ 700 ମାର୍କ ବୋଲି କ୍ୟାଲକୁଲେସନ ହେଲା 700 ମାର୍କରେ ରହିଲା ରେସ୍ପଣ୍ଡେଣ୍ଟ ବର୍ତ୍ତମାନ ଏଥିରେ ଅପୋଜିଟ୍ ପାର୍ଟ ନମ୍ବର 7 ଯିଏ ଅଛି ତାର ରହୁଛି 52%. ମୋର କହିବା କଥା ହେଲା ଯେ my submission is that I am having the higher qualification in matriculation 45%, higher qualification 5%, and my experience certificate 5%. That includes.
So taking 45%, according to him, you have 10 points have to be added. 5% for higher education and
total mark of the respondents would have been 50% instead of 58%, my lord. Thereafter, regarding experience certificate, the respondent has never agitated before the selection committee. My lord, now it is not in dispute. With respect to the other person, my lord, that another 5% additional mark is to be there. My lord, the records of the selection committee and other things, my lord, that doesn't reveal that he had applied for the same and he had asked for the same.
Unless it is your case that did you produce any experience certificate?
Yes, well, I had perused, I had obtained it under RTA that what documents I had applied at the time of selection.
That is, where is your experience certificate?
47, my lord.
Page 47.
Oh, page 47, my lord, Annexure 6.
Certify that she is as instructor at Gouda Bahai UP.
A project on
non-formal scheme has been abolished from
Education District, non-formal.
Whether this will amount to an experience certificate or not, I do not know, but there is an experience certificate. Experience as what? Where is the advertisement? Let us see.
Yes, my lord.
Whether working as a non-formal teacher or instructor rather, whether it amounts to having experience as required under the advertisement or not is the question.
Yes, advertisement spells this. My lord, that is on Annexure 1.
Annexure 1.
Page 13.
Yes. Where does it say so?
That's the column number 4.
Column number 4. Yes.
ତାଦେହରେ ଦେଲା କ ଖ ଗ ଘ ର ତାଦେହରେ ଲେଖା ମ୍ୟାଟ୍ରିକ ଠାରୁ ଅଧିକ ଶିକ୍ଷାଗତ ଯୋଗ୍ୟତା 5, ସର୍ବଶିକ୍ଷା ଅଭିଯାନର ଅଭିଜ୍ଞତା ହଉଛି 5. ଏ ଦିଟାକ ମିଶିଲେ 10% ହେଲା ପ୍ଲସ୍ ମ୍ୟାଟ୍ରିକ ଡୋଜ.
This non-formal is under Sarva Sikha.
Yes, my lord. This is
My lord, lordship may be remember. ସର୍ବଶିକ୍ଷା ଅଭିଯାନରେ ଅଭିଜ୍ଞତା ବ୍ରାକେଟ ହଉଛି ଇସିସି.
yes, ECC.
ଇସିସି ର ତ ଏଠି ଇସିସି ସେଣ୍ଟରରେ ସେ କାମ କରୁନାହାନ୍ତି. This
Non-formal is
expense no-
probably ECC.
No, ECC centers are there, madam. In one of the case, my lord, your lordship had also directed me to produce that notification with respect to establishment of the ECC.
Yes, no, that I remember.
So that ECC centers are to be actually, these are to be established, my lord, at the level of the schools.
Yes.
So into consideration that the
Let us see.
requirement of the,
Let us see page 47 for a moment.
yes,
yes.
this is to satisfy
Yes,
Satyam Rao was engaged as instructor, NFE instructor, my lord.
NFC from
A project under Jajpur 2,
Yes.
Jajpur, the non-formal scheme has been abolished with effect from 1 January 2001. So initially se non-formal thile.
Non-formal ଥିଲେ ସେ. So whether this can be taken into consideration.
That has to be decided. Well,
Yes.
Learned AG Act on behalf of opposite party numbers 1 to 6. Issue notice to opposite party number 7 by registered post with AD returnable within 4 weeks. Requisites be filed within 3 working days. List this matter.
9th October.
Huh?
9th October.
9th October. In the meantime, IRA.
for stay operation of the annexure 5.
Operation of order dated 24/7/2024.
My lord,
Passed by ADM Jajpur in AWW miss appeal number. So also they can shall remain state till the next date.
I do not else.
Lordship. The petitioner is challenging the order of disengagement issued by the Sarpanch Lordship. Sarpanch is not the authority to disengagement from the post of Joanna's Lordship.
I think there were specific subsequently, yes, there were some guidelines.
Yes.
Gram Panchayat.
No, Gram Panchayat that issued this letter.
My appointing authority video has
No, your appointing authority may not be the video.
yes, Lordship. Annexure 1 the
As
my
the-
see the merit list was approved by the subcollator and video issued engagement order, your Lordship. Annexure 1, your Lordship, page 11. And thereafter, Sarpanch allow me to work, your Lordship. And your Lordship,
No, the appointment letter was the if I remember correctly, the appointment is that there is a panel of names. The panel of 3 names is to be prepared at the level of the video, which is to be referred back to the Panchayat. Now, Panchayat has issued this. ଆପଣଙ୍କ ନାମ ପ୍ରଥମ ସ୍ଥାନରେ ରହିଥିବାରୁ ଗୋଷ୍ଠୀ ଉନ୍ନୟନ ଅଧିକାରୀ ବରପାଲିଙ୍କ ପତ୍ର ସଂଖ୍ୟା ଅନୁଯାୟୀ ଆପଣଙ୍କ 7 ଦିନ ସୁଦ୍ଧା ଅମୁକ ଗ୍ରାମ ପଦରେ ସ୍ୱତନ୍ତ୍ର ନୋଟିସ ଦ୍ୱାରା ଜଣାଇ ଦିଆଗଲା. So this is the appointment letter. Two letter.
my Lord, annexure 1, as per the merit,
October 2023.
that as per the merit panel list for appointment of Jogana Sayak in Barguda approved by the subcollator Bargad by letter number so and so.
No, I think there is a guideline. There is a comprehensive guidelines in this regard. I think I remember correctly that it is the Gram Panchayat. It has been clarified by the government that it is the Gram Panchayat which is the competent authority. Being the appointing authority, it becomes the disciplinary authority or the dismissal authority.
My Lord, kindly see the dismissal.
অনিয়মিততা
My Lord,
ও
your
দলীয়
Lord say has been,
দায়িত্বহীনতা.
my Lord, nothing clarification or
This is very
non-specific, your Lordship.
yes,
Gram Panchayat has to be issued.
yes. Learned AG accepts notice on behalf of opposite party numbers 1 to 4. Issue notice to the opposite party number 5 by registered post with AD returnable within 4 weeks, requisites within 3 days. List this matter. 9th October.
My lord, I have filed a IE, your lordship. In the meantime, BDO has published advertisement to fill up my post, your lordship.
Where is that advertisement?
My lord, annexure A series of page 6 of the IE, your lordship. On 25/7 last month, your lordship.
As an interim measure, it is directed that no selection shall be made pursuant to the advertisement dated 25/7/2024 till the next date.
Item number 13.
ପାସୱାର୍ଡ କରିବ ଏଟା ନନ୍ ଅପେସ ଗଥର ହେଇଥିଲା ଗଥର ବି ନନ୍ ଅପେସ ହେଇଥିଲା ତ ଦେଖିବା କଣ
Item number 14.
yes
Your lordship may remember that matter where the appointment letter of the petitioner has been cancelled under annexure 7.
you filed a consolidated rate application.
The consolidated prayer portion.
Whatever.
Yes, madam.
Okay.
By order dated 25th July 2024, my lord has filed. Mr. Swai was appearing for the directed to take instruction.
25
7/2024, man.
এই গোটে অর্ডার সাইন ହେଇନି yes
Well,
you
here
can come to this side, Mr. Swain. You can come to this side.
yes. Annexure 7 is the order. Lordship have a glance. And withdrawal of the offer of appointment to the petitioner. What had happened, my lord? In fact, my lord, the petitioner paid the records of selection. He was selected, was issued with the order of appointment. Thereafter, he was not allowed to join. After that, he approached this honorable court. This honorable court issued notice to the institute. After receipt of notice, my lord, the annexure 7 was passed. That and they have rejected by cancelled the appointment letter of the petition on 2 grounds. First of all, they said that there is no vacancy. They reserved the post was not reserved for PH category for which post the petition has been selected. Thereafter, they have stated that as per their direction, the petition disability certificate issued by the CDMO. They said that the CDMO has issued the letter disability certificate where the father name of the petitioner has been mentioned at Prabhas, that is PRABHAS instead of PRABHAS, Prabhas. And subsequently, a query was made by the institution from the CDMO where it was stated that yes, a certificate has been issued in favor of Ramshankar Mahanti, but his father name was Pitavasma. But subsequently in the rejoinder, I have given the document that CDMO has clarified, that is annexure page 8 of my rejoinder. But my lord, it was specifically mentioned that in the aforesaid letter, my lord, may I read that? In the aforesaid letter, it was wrongly mentioned that son of Pitavas Mahanti instead of son of Prabhas Mahanti. So the CDMO has clarified that the certificate issued in favor of the petitioner by the CDMO and that there is no ambiguity in the certificate. In the cancellation letter, they stated that since the father name, there is ambiguity in the name of the father of the petitioner, so they cancelled it. Another ground is reservation matter. But so far as the reservation is concerned, the lordship have a glance the annexure 1 is the advertisement. They have specifically stated that number of vacancy indicated above content post reserved for SC, ST, OBC, OH, as per the Government of India rules, even if, my lord, there is no reservation for that post, my lord, they still then they have to keep, because in view of the that judgment, your lordship, on the last occasion, I was Union of India versus National Federation of the Blind and others, so that
Put the position.
what a copy. 1310 SCC 772. The last paragraph 52, you'll also have a glance. There is a case where no. Paragraph 52, thus after careful consideration, we are of the view that the computation of reservation for the person with the disability has to be computed in case of group A, B, C and D post in by computing 3% reservation on total number of vacancies in the cadre strength, which is the intention of the legislature. Accordingly, certain clauses in OM dated such and such 29/12/2005, which are contrary to the above reasoning, are struck down, and we direct the appropriate government to issue new office memorandum consistent with the decision rendered by this court. So reservation they have to make for that. Another decision I could not got it xerox due to current failure, my lord.
And below it is said one post is reserved for PHOS for junior assistant.
Yes, below they have mentioned. But my lord, in fact, they have selected me against the post reserved for PH category.
No, what is that post you are applying? You have applied for junior assistant.
Junior technician.
Junior technician.
Junior technician.
Junior technician could be junior technician.
Junior technician. Junior
But they have
technician.
specified that it is available only for junior assistant.
Yes, they are specified. But so far as the selection of the petition is concerned, they selected him against the PS category, because, my lord, after his selection, they asked him to obtain another fresh certificate, because I submitted the old certificate. That is why this is asked me to file the fresh certificate. And fresh certificate I obtained and submitted this. Only because I was not allowed to join for some days, and I was made to visit the office time and again. I approached the Honorable Court that for a lordship in the another writ petition. After getting notice in the writ petition, well, that order of cancellation has been issued.
Yes.
And on the last occasion, lordship may remember, lordship directed my friend to take instruction whether the petitioner can be.
Yes.
So, often instruction that there is actually no vacancies there with regard to PH category. So they say when there is no vacancy, we
Is there any general vacancy available?
general vacancy, the PH category apply for his case is to consider. General category is not selected because his mark is far less than the cutoff mark. The fact is here is that the fact which has been submitted before lordship in a distorted manner without referring to the particular documents and the references to the annexures. I am filing the date chart with reference to all documents.
This is an affidavit. Okay.
Yes, with affidavit, I have not given this. We also turn to page 2. Page 2 with regard to what he has challenged. He has challenged answer 4 and 7. Then serial number 1.
Yes.
That IIT Bhubaneswar issued advertisement dated so and so for several non-teaching posts, including 13 posts of junior technician. There was no reservation for the post of junior technician under PH category. No reservation. Then 2011, petitioner, knowing fully well that there is no reservation under PH category, had submitted his application dated 2011, that is annexure A by 1, indicating therein are serial number 8 that he belongs to PH category. So he himself, knowing fully well there is no vacancy of PH category, he indicated that he belongs to PH category. That is the confusion started from there. but no PS certificate was enclosed to the application. This is also further important that no PS certificate was enclosed to the application form, but he has indicated he belongs to PS category. Pursuant to letter dated 17/5/2013, petitioner appeared in the written examination and thereafter pursuant to letter dated so-and-so, petitioner appeared for trade test and interview on 15/11/2013. Since petitioner submitted his application as physical handicap category candidate, inadvertently and erroneously his case was considered under that category and offer of appointment letter dated 17/1/2014 was issued to the petitioner to join on or before 17/3/2014. So only offer of appointment has been issued, no appointment letter. There only offer of appointment letter has been issued. That in the said letter, it was categorically indicated that the petitioner is required to submit all the relevant documents in original at the time of his joining as per the list enclosed at Annexure 1 to the said letter, without which he shall not be allowed to join. So as clearly indicated, he has to submit all original documents at the time of joining. If he failed to submit, then he will not be allowed to join. Further, it was also indicated in that letter, if any declaration is given or information furnished by the petitioner is found to be false, or he is found to have willfully suppressed any material information, he will be liable for removal from service and other action as the institute may deem necessary. Then 14/3/2014. Petitioner appeared before OP number 3. 17th was the last date. He appeared on 14/3, before 3 days before, and requested for some time to submit his disability certificate. So he himself appeared and made an application to give him some time so that he will produce the disability certificate. Originally, he has accordingly, by letter dated on the same day, petitioner was granted time till 24/3/2014 for submission of his documents and to submit the joining report. So on the basis of his application, that there is some problem, personal problem is there, he could not arrange the PS certificate. So time was granted till 24/3/2014. Then 15/3/2014, petitioner submitted his joining report on 18/3/2014 along with one PS certificate dated 15/3/2014. The 15/3/2014, that is after 14/3. After the last date of petitioner submitted his joining report on 18/3/2014 along with one PS certificate dated 15/3/2014 Annexure CY1 issued by CDMO Cuttack. The said PS certificate was found to be defective as the name of the petitioner and his father was indicated as the can see the name Rama R.A.M. Rama Shankar Mahanti. Originally his application is R.A.M. Rama Shankar Mahanti, son of Prabhas Mahanti. In the application form, it is Prabhas Chandra Mahanti. Whereas in the application form, Annexure A/1, it was written as Ram Shankar Mahanti, son of Prabhas Chandra Mahanti. So there is discrepancy in the name. Since doubt arose, thereafter by letter dated 2014, the CDMO Cuttack was requested to certify the genuineness of the certificate in order to verify regarding discrepancy in the name of the petitioner and his father. The letter was issued. On the basis of that letter, before we receive any intimation from the CDMO, he has approached this Honorable Court immediately. On 23/2014, we asked for clarification from the CDMO.
What happened to that earlier writ application?
This is along with this. Today is there.
It is
It was there.
No, but it has not been disposed of.
Disposed. It is still pending. Then WPC 6010 of 2014 was filed by the petitioner. Then 27th, CDMO Cuttack, by this letter dated 27/3/2014, intimated that the disability certificate has been issued in favor of Rama Shankar Mahanti, son of Pitavas Mahanti. While considering the case of the petitioner, it was found that as per advertisement, there is absolutely no reservation for the post of junior technician under PS category, and therefore the case of the petitioner should not have been considered for the issue of offer or appointment letter. Since petitioner, in order to deceive the authorities, the offer party has indicated in his application form dated 2011 Annexure A/1 that he belongs to his case was taken into consideration and he was inadvertently issued with an offer of appointment letter dated 17/1/2014 Annexure 5. Moreover, there were also discrepancies in the handicap certificate dated 15/3/2014 of the petitioner with regard to his name and name of his father. Then, besides that, even if the case of the petitioner is considered under this general category, then also he will not be selected as he has secured 15 marks, whereas the cutoff mark for general category is 20. So he has secured 15 marks, but for the handicap person it was 10. He has secured 15, therefore he was selected. And wrongly open letter was issued. Therefore, OP number 3 issued letter dated 22/4/2014, answer 7, that is the informed letter to the petitioner indicating the above fact and intimated him that his joining report cannot be accepted. Therefore, the present writ application has been filed. So this present writ application has been filed saying that he has been selected or other things as if he is not aware of the fact that there is no post under PH category is there. There is no reservation at all. Knowing fully well this true state of affair, he is aware. In spite of they had applied. And ultimately, before his joining, that mistake we got detected that he has been offer of letter has been issued by mistake, inadvertent mistake, only relying on the application he has submitted in the PH category candidate. And that has been rectified before accepting the joining report. And the joining letter itself will say if any discrepancy is found or any mistake is found, your joining will not be accepted. That we have also indicated in the joining offer of appointment letter itself. So here in the present case, there is principle of estoppel will not be applicable in the present case because before altering his position or before any step he taken to his detriment, we have detected the mistake immediately and we have issued the cancellation letter. We have issued. That is paragraph 5. It is humbly submitted that petitioner himself was
I've read it.
Yes, ma'am. And I am also relying on the two important decisions of our High Court, that is 93 Odisha full bench page 27 and here 1987 Odisha page 38. 93 Odisha full bench decision is clearly to the point, plain facts of this case. This is Sansaria's judgment. I am placing only quickly. That is 93 Odisha page 20. In the relevant portions, quickly. Paragraph 10. Paragraph 9. A mere application for job cannot therefore be said in any of the sins. In that case, what happened? After declaration made by the authorities, he had applied for the job and thereafter, before he could be appointed by any other post, the mistake was detected and it was admitted that in that case, court has held, mere application for job cannot therefore be said in any of these sins in which the word change has been defined above to bring or alteration of position of the petitioner. In the aforesaid view of the matter, it cannot be held that principle of promissory estoppel has application to the facts of this case. Then that has been elaborately discussed. Then paragraph 10. Because of the above, we are of the view that public interest and equity demands that the doctrine of principle promissory estoppel should not be extended to that extent where cancellation of the result would not be permitted by the courts virtually in any case, which would be the effect if the ratio of prosecution's case is upheld. That apart, it may principle of promissory estoppel is available only where the person concerned has changed or altered his position. Taking up steps like application for admission in higher courts or seeking a job or registration with employment exchange would not amount to change or alteration of position. We therefore hold that prosecution is untrue. Then, paragraph 17. In support of the legal position that if the concerned person has knowledge about this true state of affair, in the present case, he is aware of the fact from the very beginning, from the advertisement itself, that there is no post of physical. In support of the legal position that if the concerned person has knowledge about the true state of affair, principle of promissory estoppel would not apply. Our attention is invited to a number of bench decisions of this court. The first of which is Suresh Chandra Chaudhary versus Barampur University, 1987, Odisha, page 38. In that case, the bench principally relied on the decision of the Supreme Court. The Saganlal Keshablal Mehta versus Patel Narendra Das Haribhai, AR 62, Supreme Court 1-1, in which one of the requirements of the estoppel was said to be that the person concerned must show that he was not aware of the true state of things, or that he had no means to know the same. Even if he says that I don't know, even he has to show that he has no means to know the correct state of affairs. Must show that he was not aware of the true state of things, or that he had no means to know the same. In Suresh Chandra, the applicability of the doctrine of estoppel was rejected because the petitioner could have known on the basis of the mark sheet supplied to him, relying on which admission to the higher class was taken, that he had failed in the examination in question. Therefore, as the petitioner had means of knowing that he had not succeeded in the examination and had indeed failed, it was held that the university was not stopped from declaring subsequently that the petitioner has failed. The ratio of the applied in so many other cases of our High Court and other courts also. And therefore, we have no hesitation at all in accepting the aforesaid proposition of law as if a person knows or has means to know the correct state of affairs. There can be no question of his acting on anybody's representation that a particular state is correct, though it is not so. And ultimately, it is held that if a person has got the means of knowledge or he has got the knowledge of true test of affairs, will not be applied.
That's all?
Yes. So in this present case, I pray that
1 minute brief reply. 1 minute.
Lordship, again, your Lordship may turn to Annexure 1.
I will look at it.
Annexure 1. But they have specifically stated that the number of vacancies that NB1 below. The number of vacancy indicated above contain post reserved for SC, ST, OBC and OH. In addition to that, one post is reserved for junior assistant. But the fact remains that automatically the reservation is there. And it has to be, because otherwise that they would not have indicated the same. And they cannot say that they have not considered any person belongs to physically handicapped category other than the post of junior assistant. And that is the reason why they consider my application against the post of reservation category for physical handicap, and your Lordship again down to cancellation order, that is Annexure 34.
You have already said it.
One thing. No, they said that I went to them and said that I will file the certificate. That is not the correct. That is my submission. They stated that you were called upon to submit your disability certificate. So I was directed by the authority, since my case was considered against the physical handicap category, I was directed to submit the fresh certificate. So far a discrepancy is concerned, your Lordship is convinced that the pronunciation is the discrepancy, otherwise no. And so far as the name of the father of the petitioner Pithavas is concerned, I don't know under what it has been clarified. So the knowledge that I had knowledge that no post was reserved for physically handicapped, that is not correct, because it was there in the advertisement. They have specifically mentioned that the posts are reserved for SC, ST, and according to the reservation, it will be there. And in that judgment, your Lordship have a glance.
Excellent.
The last.
Excellent. All right. Hearing concluded, judgment is out.
What is
Parties may file the note of submission.
what are it?
And memo of citation, see if any within a week.
Yes.
Citation दे दीजिए already. Citation में तो already.
General order. If you want, you can. If you don't, if not, it's all right. It's already on.
Citation में जेरॉक्स कॉपी दे दीजिए.
Sri Sanjeev Shwani, Learned Counsel appearing for the. I think you are the Central Government Council.
Senior Panel Counsel.
Yes.
What is your designation?
Senior Panel Counsel.
Sri Sanjeev Shwani, Learned Senior Panel Counsel of Union of India, files an affidavit with the date chart in court after serving copy on the other side. Same be kept on record. After hearing heard further arguments, hearing concluded, judgment is out. Yes.
I'll 5 AM only.
Please.
Tuesday.
Yes. No, 1 week.
I don't know, 15.
Pursuant to the Lordship's order dated 8/8/2024, the state has filed affidavit, but not in accordance with your Lordship instruction, your Lordship.
Have to use the candidates.
Permitted.
Your lordship specifically direct.
My lord, in fact, my lord, it is a mistake on our part, my lord. That actually we prepared, my lord, previously, my lord, the annexure was up to annexure A/4. We prepared a counter affidavit, my lord, complying your lordship's direction. There, my lord, we annexed annexure B/4, C/4, D/4. Then we further found that your lordship had also put a question that whether the petitioner who belongs to SCBC category can also be considered against the UR vacancy or not. That additional information, my lord, we actually provided through annexure E/4. Inadvertently, my lord, this the additional affidavit, which has been annexed as annexure E/4, my lord, that has already been filed, my lord, through e-file on 21st/8/2024, which a copy of the same, my lord, we have sourced.
It is A/4 touchy. There is only A/4.
For certainly E/4 level.
Probably receive
hard copy টা भी দিয়ে দিচ্ছি কিন্তু annexure B/4
additional affidavit.
yes my lord. My lord, another affidavit, my lord, annexure with annexure B/4 C/4 D/4, my lord,
They are not there.
no, that is actually, my lord, it has been kept with our office, my lord, and
So why don't you give it? Why don't you give it?
sir এটা ফাইলিং ভিতরে কত এটা ମୁଁ ସେଇପାଇଁ এটা annexure E/4 ଟା ବି ଆମେ করতে
Annexure E/4 is that guidelines for engagement.
that guideline. That guideline means, my lord, our intention to show your lordship had put a specific question.
Let me see my order.
Yes, lordship.
8/8/2024.
Yeah, 88,000 Purvuru. First date order. Consider personally 8 candidates, including the petitioner, had appeared state council. There was no vacancy in the SABC for the pending.
So,
Court would like to know whether the petitioner was considered in the general list of all candidates, irrespective of the social category. Responsibility. Yes. So two things: whether those 5 candidates that appeared for document verification. That is one part. Physically, whether they had appeared, and second is whether he was considered in the general list of candidates, irrespective of all reservations.
yes. So, question.
That is the law.
My lord, to the second question, my lord. My lord, with respect to that decision, my lord, that Jitendra Kumar Srivastava's case, a person having the relaxation of age and relaxation of fees, he cannot be debarred to get the copy.
আমার কাছে এটা নাহি ABCD নাহি আমি কোন দেখিবি তুমি
No,
E/4 ଅଛି
ନାଇଁ,
ଗୋଟେ A/4 ଅଛି
no,
BC ନାହିଁ
ସେଇ ଯୋଉ
BC ଆଉ D ନାହିଁ
sir, ସେଇଟା ମୋ ଆଉ ଗୋଟେ affidavit.
let it come tomorrow then
Tomorrow, your lordship. The senior is out of station, your lordship. Monday also.
My lord, we will file it by tomorrow.
Copy may be solved that.
Yes, sir, of course.
it is in that in the counter affidavit you filed it along with which affidavit
Another affidavit, my lord. In fact, my lord,
acha how Sri Yashwant Patnaik learned AGA files an additional affidavit in court
lordship may said that it is incomplete.
on behalf of opposite party number 4, but the same appears to be incomplete in as much as orders have not been
Yes.
tagged to the record.
Yes.
Leave this matter next week. In the meantime, the affidavit with all annexures filed by opposite party number 4, filed by the state, be filed again.
Item number 16.
Last occasion, your lordship has heard the matter in part. The points for consideration before your lordship in the guideline.
Clause 1 and clause 4 of revised guidelines is 2.2007 vis-a-vis the scope, object and intent of the Anganwadi scheme. Yeah. What else? Anganwadi?
Query was if any reference is available.
Anganwadi boyta kora la?
She has worked for more than 5 years. In fact.
Guidelines says
No. The parties are requested to address the court as to the effect of harmonious reading of clause 1 and clause 4 of the revised guidelines. 2.2007. Clause 1 है applications for selection of volunteers to work as Anganwadi workers will be invited from each village, Anganwadi central area, from women residing in the said village, Anganwadi central area. Therefore says
Anganwadi helper and organizer, if having the requisite
no,
qualification
4 says Anganwadi helper
and are found to be suitable, shall be selected as Anganwadi worker, provided they have worked for more than 5 years. as a OP5 has worked for more than 5
But
years.
whether she belongs to the same area and same center or not?
No, she belongs to the same village. There is no dispute.
Okay.
But belongs to another Anganwadi
Service area.
center area.
Hmm.
That is the admitted fact and there is no dispute to it.
So this is the scope of interpretation. Yes, what is your submission?
Well, the court has in the last paragraph said, hence in view of the fact that Anganwadi helper of the same revenue village can be engaged, but whereupon it has been derived, can be engaged in any Anganwadi center within the said revenue village if she fulfills other eligibility criteria. At page 22.
22
of the counter, the hard copy of the counter affidavit. That was filed of 4. At page 22.
Yeah, clear.
C by 4.
Call it clear?
The last paragraph says, in view of the fact that Anganwadi helper of the same revenue village can be engaged in any Anganwadi center within the said revenue village if he fulfills other eligibility criteria. I am inclined to order that the prayer of the appellant Kumari is rejected and the appeal is dismissed.
Another candidate has challenged the amendment, that is the order in the appeal.
No. What is you are Vidyut Prabha Panda?
No, my lord.
Then?
I am Revati Pushpalata Naik.
Pushpalata Naik.
He was the appellant.
No, I was not the appellant.
Vidyut Prabha Panda was the appellant.
Vidyut Prabha Panda was
And this
the appellant.
Pushpalata was not your party.
No.
You are Reboti bearer. Yes, Mr. Naik. You are Reboti bearer.
I am Pushpalata Naik.
Pushpalata, but here Pushpalata is not a party, some Reboti is a party. So how does this affect him? What is the fact? Please tell me again.
My lord, the petitioner was highest mark secured in the matriculation exam. The petitioner had secured 51% mark, and the OP number 5 who has been selected, he had secured 32% marks. That is the position. Thereafter, the what extra the OP number 5 was, she was working as a helper in another Anganwadi center of the same revenue village. Good Telisai Anganwadi center. I am good Malisai Anganwadi center. The two all separate Anganwadi centers. This I filed representation that disposed of. I approached this honorable court. This honorable court directed to dispose of the representation by the sub-collector. The sub-collector, while dealing with the case, she found that I have annexed the document, my lord. The annexed what my learned friend has not verified. I have annexed annexure 8, my lord. My lord.
This is another appeal.
No,
Filed by you.
Another appeal by me. Lord, the clarification friend has not I have verified. I have annexed that document. The clarification letter under annexure 10. Annexure 10, page 66. Well, this clarification letter has been issued by the District Social Welfare Officer Baleswar. But the guideline has been issued by the Secretary and Commissioner Child Welfare Department. This clarification letter has been issued by the District Social Welfare Officer.
So from the Anganwadi helper of the revenue village, revenue village can be engaged as Anganwadi worker. If any Anganwadi center within the revenue village, irrespective of Anganwadi center, are identified.
And annexure 11, I have.
So if she is working as an Anganwadi helper under any Anganwadi center of the village, then she can be considered. Yeah,
if she fulfills.
So fulfills the other criteria, of course. So what happened? What are the facts? Just briefly tell me. There was a selection.
My lord.
Anganwadi helper.
No. I am a fresh candidate.
Yes.
the OP number 5 was working as a helper in the another Anganwadi center of the same revenue village. I applied for the Anganwadi post, and I was the highest mark holder in the matriculation examination. So I ought to have been selected, but as because the as per the guideline, he OP number 5 had obtained the qualification that as a helper she has worked for more than 5 years. She was selected. My concern is, if she would have worked as a helper in Anganwadi center, then she has every right to be selected then and get preference over me. This clarification letter which I have annexed, issued by the district social welfare officer. My submission.
This is on a different point. This is whether candidate who can apply if there are multiple Anganwadi centers in a village.
Yes,
then who can apply? Can only apply if she belongs to the is a resident of the Anganwadi center area service area in question. That has been clarified. But your case is different. Your case is that the opposite party number 5 being a Anganwadi helper
of the other another Anganwadi center.
So this is not covered by this. Your contention is not covered by this clarification. Rather, there's a previous page 66. What the Balasore DSWO has said, referring to the government instruction. Who fulfills the eligibility criteria and renders more than 5 years in service shall be engaged. That is why I asked you to make a harmonious reading of clause 1 and clause 4.
Yes, my lord. That was the observation
Yes,
of your lordship.
yes. Because there is both revenue village / Anganwadi center area in question.
Yes.
So here in this case, what will be the interpretation? That is why I had asked both parties to address the court on this issue. Yes, Mr. Das.
That is what is there on record.
No, it has to be interpreted. According to the petitioner, she is the opposite party number 5 is not eligible because she was helper.
Center area.
Center area. No, helper to go to Anganwadi center ko na. That Anganwadi center is not the Anganwadi center of which this advertisement has been issued.
Yes.
So according to him, he does not fulfill the eligibility criteria. So what is your interpretation? You have to address the court on this issue. Please examine it.
Yes.
That is, I have specified it. Harmonious reading of clause 1 and clause 4.
Clause 4.
Clause 4 opens the door for Balwadi and Balwadi workers and Anganwadi helpers. It opens the door. Now, clause 1 cannot be ignored.
Clause 1 and clause 4 has to be read.
You see.
Order dated 25th of July, your lordship had wanted.
Yes, yes. No, Mr. Das, you see, if you read clause 1 says, applications for selection of volunteers to work as Anganwadi workers will be invited from each village. Very important.
Center area.
Each village / Anganwadi center area. From women residing in the said village / Anganwadi center area. So first and foremost is that she must be a resident of the village. If there are multiple Anganwadi centers, then the question of being a resident of the particular service area comes into picture. Now here, this is a case where there are multiple centers. Admittedly.
Here is a case in the same revenue village, there are 3 Anganwadi.
There are multiple? There are multiple Anganwadi centers. Then the second part comes into picture. This appears to be the interpretation. Yes. Yes, Mr. Das.
Yes, some of the day they have not clarified as to what has been the government instruction.
No, let me make it very clear. You see, only clear. Anganwadi helper and Anganwadi and organizer, if having the requisite qualification and are found to be suitable, shall be selected as Anganwadi worker provided they have worked for more than 5 years. So, the case of an Anganwadi helper of the same village, but of a different area, whether he can be or she can be considered.
That clarification, though I had sought, but they have not clarified.
Heard further arguments in part. the parties have made, both parties have made their submissions on the harmonious reading of clause 1 and clause 4 of the revised guidelines dated 2/5/2007. This court would, however, like the specific response of the state in this regard. Specifically put, comma, what would be, no, specifically put, list this matter next week. Okay.
Item number 17,
Permitted to withdraw.
item number 18,
Permitted to withdraw.
item number 19,
Content made by the petitioner has been appointed as an Anganwadi worker since 2010, Your Lordship, and she is continuing in her service. He or she has challenged the order of ADM Dhenkanal under Annex 10 in Anganwadi appeal, which was filed by the opposite party number 6 by challenging my appointment only only on the ground that I am belongs to my father-in-law residence. But fact remains, after my husband's death, I have been permanently shifted to my parental house, and accordingly I have obtained the residential certificate. And after submitting the residential certificate and after securing highest mark, I have been duly appointed. And challenging that.
Is there any interim order?
Yes, Your Lordship. And also, as for Hindu Succession 6 Amendment of Hindu Succession Act, a similar order which is squarely covered to my case, Your Lordship. Even if after marriage, residence of a daughter cannot be. This is also Anganwadi matter, it has been decided.
No, you bring that other. Rajashree Mahapatra was State of Odisha, 2002 supplementary overlap. Discuss it. Anyway, yes. So,
and I have annexed all the documents so for my residential certificate of my parents, and I have getting the widow pension from my parental house, and also voter identity card, and also voter list. So only basing on a document that obtained from voter list, just after my marriage, she produced that voter list, basing on that voter list. But here, even if ADM has not issued a notice to me, has not heard me and passed the order.
then this has to go. This order has to go.
There has been long time left.
Long time will come.
I think that.
Order ta kimti maintainable haba ya apna
Without
appeal ta ko apna suni bhi nahi other side ko notice no kari kimti haba. Long time hele bhi kon haba. Why should this court take up the jurisdiction? Tell me.
Yes, that is correct.
When she can raise all the points, she can also raise all the points before the appellate authority.
Could not.
Dated 3/2/2011, passed by the ADM Dhenkanal in AWW, appeal case number 38 of 2010, is impugned in the present date application. It is inter alia submitted that the appeal was disposed of without issuing any notice to the petitioner.
In fact, nobody else was added as a respondent except the city.
Yes, the reading of the impugned order reveals that the petitioner does not appear to have been impleaded as a respondent. Further, no notice of the appeal was issued to the petitioner. As such, the impugned order becomes bad in law and warrants interference. So, though this court is conscious of the fact that the impugned order was passed more than 13 years ago, yet there being blatant violation of the principles of natural justice, the same cannot be allowed to subsist. Moreover, if the appeal is heard again with proper opportunity of hearing being granted to all necessary parties, the same shall not cause prejudice to any of them. Stop. Virtue of the matter, the writ application is allowed. The impugned order dated so and so is hereby quashed. The matter is remitted to the ADM ढेंकानाल to consider and dispose of the appeal filed by the present opposite party number 6, Arati Jala. Afresh, after granting proper opportunity of hearing to the petitioner and all other necessary parties, if any. Stop. Since the dispute is of the year 2010 or 11? 10. The ADM shall do well to dispose of the appeal as early as possible, preferably within a period of 2 months from today. Yes.
Good time. One thing I want to say, my lord, your lordship has indicated that no notice has been issued. In fact, from the order, it doesn't transpire that any notice has been issued. But he has not filed the entire order sheet. Whether previously there was notice was issued, but subsequently, order so your lordship appears to have been.
I am clarifying. So, far respondent number 3 is concerned, clearly. Notice
but previous order ମାନେ ଗୋଟେ ଜିନିଷକୁ ଆମେ ଦେଖେଇନୁ ବୋଲି ସେ ଏଡିଏମ କହିବେ why you didn't show it. ଆପଣ ତାହେଲେ ଅର୍ଡର ସିଟ୍ ଆଣିଲେନି, ମୋ ପାଖରେ ନାହିଁ, ମୋର ଫାଇଲଟା କୁଆଡେ ମିସପ୍ଲେସ୍ ହେଇଯାଇଛି, ପ୍ରୋବ୍ଲେମ ହଉଛି ସେଇଟା। କିଛି ଆଉ ଫାଇଲ ଖୋଜିବେ କାହିଁକି, ସରିଲା ତ।
Item 20.
Item 20, my lord.
The name of say Joseph Sengupta be deleted from those.
My lord, item 20, my lord, on behalf of Mr. Mahapatra, my lord, taken up next week, my lord, he is suffering from dengue, so my lord, in last
2011. Matter anyway.
Next week, my lord.
Therefore, adjournment is made. Next week, say recover करते हुए ना करते हुए तो तापर week recover. Therefore, adjournment is made on behalf of Siddhartha Mahapatra on the ground that he is suffering from dengue. This is matter. 5th September. 5.
21.
Petitioner is challenging the order dated 5/4/2011 passed by the ADM Baleshwar, the Anganwadi appeal, where this appeal preferred by the present petitioner has been dismissed, whereby his non-selection has been confirmed. Tune order is under Annex 3, Lordship.
Annex 3 is input order.
Page 25.
What happened? What is the facts? Tell me.
The opposite party number 3 has issued an advertisement inviting application from the eligible candidates for Anganwadi workshop. That is an Annexure 1. Pursuant to under Annexure 1, this petitioner has applied for 2 Anganwadi centers on the ground that he has been working as a Balwadi worker for last 10 years. And as per the clause 8 for claiming under clause 8 under Annexure 2, he has also submitted the experience certificate issued by the executive officer that he has been working since 2001, and till that time he was continuing as such Balwadi worker. Here she has not been selected. is approach the ADM when no steps has been taken. Honorable Court, but filing the writ application. This Honorable Court is disposed of the writ application with a direction to prefer appeal, Lordship. And pursuant to direction of this Honorable Court, appeal has been preferred, and same as the impugned order is under Annex 3, Lordship. Here, Lordship, the petitioner is claiming his appointment on the ground of the clause number 8 of the advertisement, that is page 12, Lordship, the writ application. With Lordship's kind permission, may I please? विज्ञापित अंचल परिसर निर्दिष्ट राजस्व ग्राम बा निर्दिष्ट अंचल केन्द्र परिसर मध्य बालवाड़ी कर्मी भाव 5 वर्ष कार्य करथिले संपृक्त आवेदनकारिणी सही केन्द्र रे अंगनवाड़ी कर्मी रूपे चयन करा जिवो जदि बालवाड़ी कर्मी 5 वर्ष रु कम कार्य करथिबे
विज्ञापित अंचल परिसर निर्दिष्ट राजस्व ग्राम बा निर्दिष्ट अंगनवाड़ी केन्द्र परिसर भितर अंचल परिसर भितर माने बोथ रेवेन्यू विलेज सर्विस एरिया যদি আপন বালবাড়ি কাম করতে তাহলে ইউ ক্যান বি কনসিডার্ড ওকে
and subsequently it has been said that this যদি বালবাড়ি কর্মী 5 বর্ষରୁ কম କାର୍ଯ୍ୟ କରିଥିବେ কিংবা সম্পৃক্ତ কেন্দ্র নিমন্তে আবেদন ন କରନ୍ତି তাহলে সেମାନଙ୍କ প্রার্থীত্বକୁ বিচারକୁ নিয়াଯିବ ନାହିଁ ଯେଉଁ କେନ୍ଦ୍ର ପାଇଁ ବାଲବାଡି କର୍ମୀ ଆବେଦନ କରିଥିବେ ସେହି କେନ୍ଦ୍ରରେ ଅନ୍ୟମାନଙ୍କର ଦରଖାସ୍ତକୁ ବିଚାରକୁ ନିଆ ନ ଯାଇ ସେମାନଙ୍କର ଦରଖାସ୍ତକୁ ରଦ୍ଦ କରାଯିବ ସେଥିପାଇଁ ସମ୍ପୃକ୍ତ ବାଲବାଡି କର୍ମୀ ମାନେ ସେମାନଙ୍କର ଅଭିଜ୍ଞତାର ସାର୍ଟିଫିକେଟ ସମ୍ପୃକ୍ତ ଅଧିକାରୀଙ୍କ ଠାରୁ ଗ୍ରହଣ କରି ଦରଖାସ୍ତ ସହ ସଂଲଗ୍ନ କରିବେ ଯଦି ବାଲବାଡି କର୍ମୀ ଭାବେ ମ୍ୟାଟ୍ରିକ ପାସ୍ କରି ନଥାନ୍ତି ତାହେଲେ ସେ ଚୟନ ହେବା ଠାରୁ 3 ବର୍ଷ ମଧ୍ୟରେ ମ୍ୟାଟ୍ରିକ ପାସ୍ କରିବାର ଲିଖିତ ଭାବେ ଅଣ୍ଡରଟେକିଂ ଦେବେ This present petitioner has passed the matriculation high school certificate examination and also annexed the matriculation certificate, also the experience certificate issued by the executive officer of the NSC Lordship. Here, Lordship, my appeal has been rejected on the 2 grounds. First, that I have applied for 2 posts. A little fact, Lordship, that while working as an Balwadi worker in the Pathan Mohalla A, which the petitioner has applied, she got married to a person who has been belong to Mubarakpur. The petitioner applied for both, for Mubarakpur. Now she is claiming that she is working for 10 years as a Bangalwadi worker and no other applicant has been claiming under clause 8. She is entitled to get that appointment order. Now that has been rejected on the ground. He is an outsider. He got married. So therefore, she is not eligible.
Place the impugned order.
Fine. The contention of the opposite party number, respondent number 3, opposite party number 3 here, starts at 6, Lordship, of the impugned order.
I think we can straight away come to page 27.
Well,
Gone through the documents available on the record and written arguments submitted to it is seen that the appellant
last refer it is seen that gone through the documents available on record and the written arguments submitted by the parties. It is seen that the appellant has filed the application in respect of Pathan Mohalla A, Mubarakpur Anganwadi Center, as she was working as a Balwadi teacher in Pathan Mohalla Anganwadi Center. The selection and engagement of Anganwadi worker is being governed as per the Government of Orissa Women and Child Development Department. Guideline issued under letter dated 2/5/2007. As per paragraph 5 of the revised guideline, it has been depicted that the consequent upon the closure of Balwadi Center in ICDS area, the Balwadi workers having requisite qualification as provided under paragraph 3 shall be selected as Anganwadi worker if they are found otherwise suitable and have worked more than 5 years. Now, Lordship, is this guideline paragraph 3, Lordship? It says, Lordship's kind permission, place that 3A and 3B. In PGT area, the female candidates who have highest qualification among the applicants for each Anganwadi center area Anganwadi worker, in case there are more than one candidate with the same qualification, the person who is senior in age may be selected. Then some clause B says about the schedule areas, Lordship. Now the 5 it comes under 5A of that guideline. A Balwadi worker can be engaged as Anganwadi worker provided she has worked as a Balwadi worker on the particular village. A Balwadi worker not having matriculation certificate can be engaged as Anganwadi worker based on undertaking that she will have matriculation examination 3 years of her engagement, Lordship. Now, advertisement has been issued on 29/3/2010, Lordship. This experience certificate was been issued on 5/4/2010, and the language is the Ruxana Khatun, the present petitioner, has been serving as Balwadi teacher in Pathanmola Balwadi Center in ward number 5 of this NSC since 15/8/2001 till today. So by the time the advertisement issued, it has been the experience certificate so that she is continuing to work as a Balwadi worker lordship, and no other applicant has been claiming as Balwadi worker lordship. The appeal has been rejected on the ground ki first for Pathanmola Anganwadi Center, where she was working as a Balwadi worker. They says that residential certificate has not been provided for Pathanmola, and for Mubarakpur they says is outside area lordship.
Well, who's appearing for the other side? You are for the private opposite party. What is the state? No, just before I ask you, what is the response of the state?
We have filed a counter, my lord.
Yes.
Justifying that particular stand, what we have taken in the appeal. The relevant
How
parameter.
is she ineligible? How, according to you? So admittedly, she is working as a Balwadi worker.
As it has been placed before lordship.
Yes.
The impugned order. What I found, my lord. Paragraph number 5 has been quoted.
Paragraph 5?
Page number 28 of the impugned order.
28.
As per paragraph number 5 of the revised guideline.
But that is totally not related.
No, my lord. Lordship may refer the book, my lord.
Oh.
There is another amendment to
Sir,
that.
amendment is
that is 5A.
5A or 5B?
Say 5A, they have specified that it is in a village.
No, a Balwadi worker can be engaged as a Anganwadi worker provided she had worked as Balwadi worker in that particular village.
So that has not been taken. I think so. Only with respect to para number 5, my lord, a reason has been assigned. That has been.
That was amended when?
2009. And the advertisement of 2010.
Prior to this order. Yes.
The advertisement was 2010.
Yes, Mr. Martin. This aspect has not been considered.
This particular aspect, my lord, I think
5A has not been
considered.
gone by 5. The unamended provision.
It has been placed by her, my lord.
Yes, that is
it has not been. That line.
ନା ସେ ଆଉଥରେ କନସିଡର ମୋର କିଛି ଆପତ୍ତି ନାହିଁ ଆଉଥରେ ତାଙ୍କ କଥା କନସିଡର କରନ୍ତୁ କିନ୍ତୁ
you will also be heard, not that you will not be heard. You will have to be heard.
No, I am working since 2010.
No, sir, your job will be protected. You will not be removed from the job.
ସିଏ ତାଙ୍କର ଚାକିରି ଯଦି ପାଇବେ ଗଭର୍ଣ୍ଣମେଣ୍ଟ ତାଙ୍କୁ ଦେବେ ମୋର ଆପତ୍ତି ନାହିଁ କିନ୍ତୁ ମୋ ଚାକିରିଟା ଯେମିତି
ଆପଣ ଚାକିରି ନ ନେଲେ ସେ ପାଇବେ କେମିତି?
ନା ମୋ ଚାକିରି ନେବାର ନାହିଁ ସିଏ ଭାବୁଛନ୍ତି ବାଲୱାଡି ବର୍କର ସିଏ ଯୋଉଠିକା ରେସିଡେଣ୍ଟ ସେଇ ରେସିଡେଣ୍ଟ
ଭିଲେଜ ପରେ କହିଲେ
ନା ତାପରେ ଚେଞ୍ଜ
provided that she had worked as Balwadi worker on in that particular village.
ସେ ଥିଲେ 5 ନମ୍ବର 12 ନମ୍ବର ବର୍ତ୍ତମାନ
ସେଟା ତ ଅଙ୍ଗନବାଡି ଆପଣ ସେଣ୍ଟର ଏରିଆ କଥା କହୁଥିଲେ ଭିଲେଜ କଥା କହୁଥିଲେ
ଭିଲେଜ ବା
ଭିଲେଜ ଟା ଟିକେ ବଢି ଯାଇଛି
ଆଉ ଥରେ ତାର କନସିଡର ହଉ ନାଇଁ ସର୍ଭିସ ମେ ପ୍ରୋଟେକ୍ଟେଡ ମୁଁ 2010
I did not really pass any order because you are already protected. There is no order against you. The order dated
OP number 6
5/4/2011
passed by ADM Baleswar in Anganwadi appeal case number 76 of 2010 challenge. In course of hearing, it has been pointed out that as disposed of the appeal referring to para 5 of the revised guidelines dated 2/5/2007, which has also been quoted verbatim. But then this court finds that the provision underwent an amendment on 21/8/2009, whereby two additional sub clauses were inserted, being 5 small a and 5 small b. In course of hearing, it is further that clause A, sub 5 bracket A, paragraph 5 bracket A, clause A is relevant insofar as the case of the petitioner is concerned. For which the same ought to have been, for which the effect of the same ought to have been considered by the ADM while disposing of the appeal. So, having regard to the submission as above, this court deems it proper to direct the ADM to consider the appeal, to rehear the appeal after taking into account the amended clauses of paragraph 5 in the proper perspective. The writ application is therefore allowed. The impugned order also is hereby quashed. The matter is remitted to the ADM Balesur.
Opposite number 3, madam.
Okay?
Opposite but not 3, madam.
Opposite party number 3 to hear the appeal afresh after granting opportunity of hearing to all necessary parties and by specifically considering the effect of the amended provision, that is clause 5 bracket A, and the applicable beaten A of the revised guidelines dated 25/2007. Since the dispute is of the 2010 of the year 2010, the ADM shall do well to try and dispose of the appeal as early as possible, preferably within 2 months from today.
From the date of this, issue a copy of the.
From today.
Sir, I am for opinion number 6. My appointment under Annex A by 6 may not be affected by virtue of this order because this order has been set aside.
It is submitted that that presently the opposite party number 6 is working as Anganwadi worker
since 14/5 of Pathan
Mahalla Anganwadi Center since
14/5/10.
14/5/2010. Stop. It is made clear that she shall be allowed to continue till disposal of the appeal, and further, depending on the order that may be passed by the appellate authority.
Item 20.
To my lord, on the last occasion, so that the opposite party, the private opposite party has already got a job somewhere, and apart from that, the changes is there that the Anganwadi center for which she was claiming has been bifurcated, and she is coming under that newly bifurcated. The documents I have. Take instruction.
This case, I think I was directed.
No, he was directed actually.
Yes.
Opposite party number 5.
In fact,
that she has been engaged elsewhere, and the Anganwadi center, whether it has been bifurcated.
So, madam, to that extent, madam, I
Bifurcated.
received a copy. Yes.
And what about the
Two persons have already been engaged.
in fact, I have written a letter to the lady. I was just requesting your lordships to grant me some time to ascertain the same.
Madam, the last para.
Then State Council has obtained instructions from the DPO on us to the effect that the Godo Put 1 Anganwadi Center has been bifurcated as Godo Put A and Godo Put 1A and Godo Put 1B. And further, in both Anganwadi centers, now Anganwadi workers have been engaged since 17/9/2016, 17/12/2015 respectively. Learned counsel appearing for the private opposite party number 5, a request for a short adjournment on the ground that he has not received the instructions solicited from his client. Lest this matter On 12th September.
ଭୁଲରେ ଚିଠିଟା
ଦିଥର ଆଉ ଥରେ ପଠେଇ କେବେ ଆସିବ? 12th September. 12th September.
Item 23.
My pleasure, Lordship. I am on VC on behalf of the Reservation.
Yes, who's for the petitioner? I am for the petitioner. My lord.
There was an interim order was there initially.
See case raise. हाँ. लिख देंगे interim order का confirm कर. Interim order to confirm. Item 23.
My lord, item 23, my lord, matter relating to my lord, rehabilitation assistant scheme, appointment under the rehabilitation assistance scheme. My lord, this is the third round journey of
Rehabilitation assistance scheme in which institution?
Lord, in the East Vale Reservation.
What happened?
Third round journey, my lord. Earlier, the petitioner has approached twice, but till now his grievance is not ventilated, my lord.
Yes, what is your case, sir?
I seek a short adjournment because, my lord, yesterday night I have suffering some mental illness. That's why I am not prepared, man.
You suffering from?
Man, मुंडोटा सर बुलेला कर लिया बॉडी
Mental illness. मुंडो बिंदु मुंडो बुलेगा साला mental illness.
मुंडो
ऐसे कौन तो बांधी बुला के नहीं भर्ती कर दो कोर्ट जी प्रावधान रे हम मुंडोटा साधारण बिंदु से इतने तो
देवड़ा बोल रहे हैं
आप पढ़ पाने टाइम नेबे ଆଉ
short adjournment
की करता all right. As requested by the counsel for the petitioner, is this matter would date for the
5th September.
5th September.
Item 24.
I know, please, on 5th September I have other work. I did 4th.
12th September. 12th September. Yes.
This is matter relating to appointment of Gram Rozgar Sevak. Notice was issued in 2018, 2019.
But in this case, my lord,
Private property not returned from that it has not returned.
2 to 5 so I think 2 to 4. Take fresh notice on 4 and 5.
4 and
I have received a parabase comment on behalf of 2, 3, and 4.
4.
And my lord, they have also
Sarpanch also.
said they sent to no price. On behalf of opposite partner number 2, collector cum CEO, and opposite partner number 3, project director PDT Devgad, and opposite partner number 4, that is Sarpanch Tental Bahal GB. What they have stated. More, but I need some time, my lord, to prepare.
then I am
in the meantime, you take notice.
against only opposite partner.
Yes. Sri Hasan Patang GA submits that he has received parabase comments on behalf of opposite from opposite party numbers 2, 3, and 5. 2, 3, and 4.
Yes.
And request time to prepare and file the counter affidavit. 2 weeks time, 3 weeks time is allowed. The state council for the purpose. There is no information as to if notice on opposite party number 5 has been served or not. I don't know. Issue for notice on opposite party number 5 by registered post with ID, returnable within 4 weeks. Requisites be filed within 3 working days. Is this matter on 3rd October? 3rd October.
Residential certificate appeal re cancel hechi rescinded hechi that order has been that interim order to continue till the
Item number 26.
Lordship's order dated 5/7/2024. 5/7/2024.
I think, my lord, the order passed in the connected retreats. 9991. And
Yes, ma'am. I was required to, because although, my lord, I had obtained the instruction, but I had to file it through in the shape of an affidavit, my lord. My lord, this was, I had filed it. So, my lord, taking into consideration the para number 7, my lord, your lordship had directed to say that whether proper opportunity was given to the petitioner or not, my lord. Initially, my lord, the petition was disengaged by the DO. I think, my lord, thereafter one order has been passed by the collector. The collector's order is, no?
yes, but the collector has given opportunity of hearing while passing the order of disengagement. That was the.
My lord, to that extent, my lord, even though we had obtained the information, that sufficient opportunity was granted by the DO.
What about the collector?
No record, man. So, say ଜିନିଷଟା specifically I had taken the instruction. Say ଏଇଟା ମୋର ଗୋଟେ ଥିଲା 2024 ର ଗୋଟେ affidavit ଥିଲା
instruction
ନା ମୁଁ ଗୋଟେ prepare କରିଥିଲି. Second, yes, ma'am, yes. And well, as on date, even, my lord, I can say that opportunity at the level of the collector, my lord, it was not. ମୁଁ ଯେତିକି ତାଙ୍କଠୁ ବୁଝିଥିଲି ସେ ଫାଇଲ ଦେଖି ମୁଁ ସେଇଟାକୁ I will submit to an affidavit so that your lordship at the level of the DO, my lord, it was given. And my lord, so far the second case is concerned, my lord.
That I think, my lord, the first one, that is infructuous.
That is infructuous because we have already regularized the particular period of medical leave.
Maternity leave period.
And the amount has been sanctioned also.
No, my lord, because since they are not allowed me to join, that's why I filed. The moment I filed the treat petition, they passed the order of dissent.
So these are the
Item 27. Sir.
Okay.
Item 27.
In regards to the last order, your lordship on last occasion directed the state council to for a fair adjudication of this case to file a counter, my lord. But they didn't file, your lordship.
My lord, I am appearing for the sole. Sorry, ma'am. I am appearing for the sole private opposite party. OP number 4, your lordship.
Have you filed your no, my lord. No counter has been filed, and
may I pray one
no has filed a counter, my lord.
May I pray one thing, my lord?
To that effect, I have also filed rejoinder affidavit, my lord.
My lord, one thing may I pray, my lord. I am on accommodation because I was suffering from dengue. Till 30th, I am on accommodation. My lord, ହେଇଗଲା ଦିଲ୍ଲୀରେ ଯାଇଥିଲି ଗୋଟେ କି କାମ ଦେଲା Pardon, my lord.
You don't look like you are suffering from dengue.
I couldn't hear.
ଶୁଭୁନି ତାର 17 ବର୍ଷ dengue ହେଲାଣି କଣ?
My lord, I am on accommodation.
ଏଇଟା ତ
ଶୁଭିଲା କିଛି ଶୁଭେ କିଛି ଶୁଭେନି
କିଛି ଶୁଭେନି ହଁ ରଜା କର୍ମ ପଶ୍ୟତି ରଜା କୁଲେନ ପଶ୍ୟତି ସେଇଭଳିଆ ଆଉ
କିଛି ନ ଶୁଭିବାର ଅଭିନୟ ବି କରେ
So we'll take it up next week. In the meantime, you file a counter. The counter is necessary by the state.
It is an appellate order which is not a challenge.
Maybe, but after hearing, I felt that a counter is necessary. Some clarifications are.
Instead of taking the matter.
Maybe one week thereafter.
30 तारीख को ना है सर नेक्स्ट वीक.
Okay, okay.
And next.
As counsel, is this matter?
5th September.
On 5th September, counter will be filed in the meantime positively.
Yes, ma'am.
28.
The parties are requested to come ready for final disposal of the matter.
Yes, sir.
Absolutely.
Item 28,
The matter may be taken on some other day, my lord.
some other day, next week as paid for.
Item 29.
29 may lord. Counter not filed. Last occasion lots be directed.
So you not back from, let us see, I will notice the one is the
29 ଟା ମୁରଲୀ ମୁଁ ଦଉଛି.
notice on opposite party served as evidence from the postal tracking report. There is however no appearance.
In this case, my lord,
You are filing the counter.
already counter will file through e-filing, my lord. Today I am serving a hard copy.
Land State Council files the hard copy of the counter, already e-filed.
Yes.
Copy of the counter has been served upon Sri Satpatri. Who wants some time to go through the same, and if necessary, file a rejoinder. Is this matter on 19th September? Filing meantime.
Item number 30.
My lordship, on behalf of Mr. Mahanti, item 30 counter has not been filed, my lordship.
Not any problem, Mahanti. Are you ready with the counter?
Oh, my lord, on 19/6/2024, my lord, the notice was issued for the first time. My lord.
As requested by the State Council, is this matter on 19th September, counter be.
Item 31.
Please, my lord. Lordship, the mediation between the parties stands failed, my lord. With your due permission, may I seek for an adjournment, lordship?
Report of the mediator indicates that mediation between the parties has failed. Then counsel for the petitioner wants an adjournment. Is this matter on?
I am for the petition. I am for the petition.
In one case, I am petitioner, in another case, he is the petitioner. In TRP.
Hello, petitioner. Then counsel for the petitioner wants this matter on
12th September.
12th September. Interim orders to continue. In both cases. Huh?
Yes, great.
Item 32.
In this case, I am for the opposite party.
Petitioner Nanthi. Mr. Saubhagya Kumar Das was there in the morning. All right, pass over. Pass over.
Item number 34.
33 ta kaun hai? Arjun hi tera. 34.
May I please? In this case, I am appearing for the petitioner's wife, my lord. The file the two petition, my lord. One is a 125 CRPC petition, another is the 13-1 days divorce petition, my lord. They are seeking for the transfer the case family judge Puri to Bhubaneswar. Because the petitioner is the poor lady, my lord. She has been residing in the miserable condition, my lord. Petitioner and daughter are dependent on old parents, my lord. Then the Bhubaneswar residence, Balipatna, my lord. The difficulty is to up and down to Bhubaneswar to Puri, my lord. My lord.
Before proceeding any further, like I ask in every case, is there any chance of mediation so that I can send it to mediation center? Both parties?
Last occasion, the opposite parties, council, my lord, said that no, agreed to mediation center to compromise the.
Yes, Mr. Bali.
No, I will have to take instruction from my client. Last occasion, I have not said so.
It has not been, at least maybe, but it has not been reflected in the order.
Yes, ma'am.
I'll call it next week. In the meantime, you take instructions.
Yes.
If it can be settled through mediation, well and good. If not, then I'll consider it on merit.
Because there are several litigation pending between the parties.
All litigations can be resolved through mediation.
Transfer matter.
Because the wife left the house.
I am not to decide that, Mr. Bali here.
Yes.
And I will consider the transfer application, provided.
Yes.
Agreeing for a settlement, well and good. Many cases are being settled also.
Yes, yes.
I've been regularly sending matters to mediation, and some cases are being settled. Not many, but some cases are being settled.
Yes.
Not affidavit filing, that is the best way of settlement of a matrimonial dispute. If not, I'll consider the application on merit. Learned counsel for the parties are directed to take instructions from their respective clients as to if the matter can be resolved amicably through the process of mediation. Raise this matter next week.
Item 35 next week.
Connected matter भी है? हाँ, connected.
Connected.
All right. Item 35.
There is the notice that the notice issued to sole of the written answer taking only 6 time to ascertain the correct postal address.
All right. Learned counsel for the petitioner seeks 2 weeks time to ascertain the correct address of the opposite party. Is this matter?
12th September.
12th September. 12th September.
Interim order
Interim order to continue.
2 ସପ୍ତାହ ଭିତରେ ରିକ୍ୱିଜିଟ୍ସ ତା ଭିତରେ ପୁଣି ଟାଇପ କରିବି ନା
नहीं आप correct address दियंतु आनंद तापर देखिए.
Item 36.
36 my lord. Lordship has sent a case for mediation, my lord.
Yes, mediation.
So the petitioner wife appeared before the mediator. But the
23 ମାନେ 23 ମାନେ ଆଜି ଅଛି. କାଲି କି ଅଛି. ଦେଖାଇଛି ପରେ?
ଆଗ ଡେଟ୍ ରେ ହଜବେଣ୍ଡ ଆସି ନଥିଲେ.
ଜାନି ଇଲେକ୍ସନ ସେ mediation pending ଅଛି ତ କ୍ଲୋଜ କରନାନ୍ତି ନା. Notice of the mediator indicates that the next date of the proceeding is fixed to 23rd of this month. Is this matter next week or no? Next week. I will go to. Is this matter on 5th September?
Interim order is there.
Interim order to continue.
37.
He may come. Who knows? Who knows? He may come. He may not come. If he doesn't come, he'll close it.
Well.
Fixed for mediation.
Already order sir. Let us not waste time. Yes, 37.
37 Lordship, by order dated 25/7/2024, Lordship was pleased to issue notice and
कौन है जी? Notice दिला हाँ कौन है? Somebody appeared.
postal tracking report is
Postal tracking report indicates that notice of the opposite party has there is no appearance. Nevertheless, in order to grant an opportunity to the opposite party to appear, let's this matter.
12th September. 12th September.
5th.
12th September.
12th September.
will pray the interim order may
Interim order to continue.
Item 38.
Petitioner wife my lord. 6 for transfer of CP case number 470 of 2024.
प्रीतम कुमार महाती. प्रीतम रो स्पेलिंग कौन?
TRITM.
TM. एटा छाई जाइछन.
Sorry.
आपन ना तो?
Yes, sir.
Pritam Kumar Mahanti, advocate and associates have entered appearance for the opposite party by filing Vakaratnama. The same be kept on record. Their names to be reflected in the cause list. Mediation, Mr. Das.
My lord, husband is working as a public prosecutor.
Yes, what do you say?
Mediation could.
Mediation करते हैं, mediation करते हैं तो date हमारा मासे पर कोई date करते हैं
9th October.
9th October.
Interim order to continue.
Interim order अच्छी already. Interim order to continue. Yes.
Item 39.
39. Oh, this is the bail.
Extension of my lordship, item 39 not placed.
Not placed.
Item 40.
See the I8 how dispose of I8 not placed.
May I please your lordship?
Item 40.
My lord,
this is the petitioner.
My lord,
Lordship already disposed of.
I'm just coming, your lordship. File modification order, your lordship. It's a small direction. That to only to direct the family court to dispose of the expeditiously because your lordship after 1 year this matter has been transferred. Both are doctor, your lordship. If your lordship, that is my only my prayer in this application, your lord.
You are for the opposite party.
Yes, lords.
I am the petitioner, my lord. Why? It was petition filed by the husband before the Baram, no, sorry, before the Baram.
Therefore, modification is allowed. It is directed that in order dated 7/8/2024, the following sentence be added after end of at the end of paragraph 7. Look further, the learned judge, family court, Barampur, shall expeditiously shall shall do well to dispose of the case as early as possible, preferably within a period of 6 months.
ସେ ମତେ କପି ବି ଦେଇନାହାନ୍ତି ମୁଁ ସେମିତି ମାଇଲର କହିଦଉଛି ଜାଣ ମତେ କପି ବି ଦେଇନାହାନ୍ତି
Item 41.
My lords. No, BLFPL 1189/24. Homework केवल 1189.
Again?
1189 था सेदिन
Again making an allegation against a
no.
Your Lordship has called for a report.
ಈ ಕೇಸಲ್ಲಿ
Report.
Report
Last time ಆಸ್ತಿಲ್ಲ.
report आज जाइଥିଲା last time.
Lordship. After seeing the report, your Lordship adjourned the matter. 1 week after.
Yes, I've said that this court observes that the delay in grant of bail can never be attributed to the counsel appearing for a party. Therefore,
Sub item 11750, the Lordship granted interim bail and availing the same, he surrendered. I have applied for the surrender certificate not get.
And what is your case?
My case is my co-accused statement. My
This person does not deserve any bail.
My lord,
This person does not deserve bail. Okay.
co-accused statement
Oh.
से जानी किसी जानी नहीं भी
ସେ ଜାଣିଛି
तार 4 मास पर
I'll reject it to go to Supreme Court.
ये 8/8/2023 रे इंसिडेंट हैला इंसिडेंट ला ये 2/1/24 रे अरेस्ट हैला को-accused स्टेटमेंट पड़ा
Please this matter 1 week after. Connected matter ରେ କହିବେ surrender certificate be filed in the meantime. ସେଟା ବି 1 week after surrender certificate be filed in the meantime. Yes.
Item 42.
Pass over. On behalf of
Pass over.
Item 43.
Offense under section 302, my lord, and two accused since custody, my lord, 7/4/2023, and two co-accused already granted bail by this honorable court, my lord.
Somebody also. Yeah.
Dispute between.
Yeah, obtain the case diary.
There need some time, my lord. I have written a letter but not come one date. And this person is on different footing.
No, anyway,
Yes,
case
ma'am.
diary is necessary.
Yes, ma'am.
As requested by Land State Council, is this matter on 5th September? Case diary be obtained as directed. Yes.
Item 44.
Oblige, my lord.
May I please, Your Lordship? Your Lordship, in this case, Your Lordship directed the petitioner to be released on the interim bail for a period of 1 month. As the wife of the petitioner is suffering from neurology disease, my lord, and now she has been admitted as an indoor patient, Kalinga Institute of Medical Science. Lordship, may kindly see I have annexed, my lord, as indoor patient, admission register. Page 6, the admission sheet, my lord.
We grant 1 month's time.
16th August, she has been admitted as per his annexure.
So that admission is
1 month. We'll extend the case. Therefore, extension made on the ground that the petitioner's wife has in the meantime been admitted to hospital. The certain medical documents have been enclosed. Considering the grounds, considering the above, therefore extension of interim bail is allowed. Stop. The interim bail granted by tolerated so and so is extended by a period of 1 month.
Item 46.
A date may be fixed.
Place this matter on. Go to court.
Hand of close.
Yes. Item 46.
Item 46.
Lordships, on the last occasion, your Lordships had granted the petitioner interim bail on the ground of his mother's illness. He took his mother to SCB, my lords, and she has been thoroughly examined, and echo and other tests are on 31/8/24. So I am praying only for another 4 weeks extension. His bail application, his surrender date is on 27. So Your Lordships must see Annexure A. Eco on 31/8/24 and
Therefore, extension of interim bail has been made on the ground that the mother of the petitioner has been advised for certain tests, including echo on 31/8/2024. On such ground, it is therefore submitted that the petitioner may be granted further time to surrender, as he has to arrange for his mother's treatment. Considering the submissions, the interim bail granted by order dated so and so is extended by a period of 4 weeks.
Obliged.
24/7/2020.
From 24/7.
Earlier on is 24/7.
24/7.
Yes,
Item 47. May please your Lordship, my lord.
Yes.
My petition language in the jail question 26/1/2021, my lord. Your Lordship, at the first instance, your Lordship was granted 3 months interim bail, and subsequently his interim bail was extended by Honorable Supreme Court, my lord, for another period, and subsequently was surrendered, my lord. Your case is that, my lord.
You also need some time, my lord. The 1 week time. He will send by tomorrow, said, but.
Well, I'll let this matter next week as per for by
Yes, ma'am.
United State Council. Up to the case diary be produced positively. Yes.
Item 48. I have also given some witness have been examined. I have.
No, I say case data also the same.
And the earlier location, your Lordship said after the examination of material witness, the eyewitnesses. So let the
5 witnesses have also.
I
have also served.
Yes, it is there.
Item 48.
May I please, your Lordship. Extension of time, my lord. On your Lordship granted bail to the petitioner and directive surrender before the London court, my lord. Filed for extension of time.
This has come for the first time?
First time, my lord.
All right, 2 weeks.
Obliged to Lordship.
Item 49.
The Lordship granted one Potessa Patra anticipatory bail, my lord. So for present petitioner is concerned, my lord, he is the driver of the vehicle, my lord. Adulteration of the tobacco, my lord.
Not named, but.
Driver.
It is alleged that the petitioner was the driver of the vehicle in which the tobacco products were.
Yes, yes.
Same order. Yes.
Item 50.
Yes, Mr. Rai.
Last day, my learned friend has taken time to collect the CD.
You go to last matter. Yes, Mr. Rai.
Case under 20B, 2C, 25 and 29.
Yes, my lord.
My lord,
There has come.
the person, those who are facing trial, they are acquitted. So, for this petitioner is concerned, they have, the police, they have procured ganja from this.
Yes, that is there. As per the co-accused statement,
This is an anticipatory bail.
Yeah, anticipatory bail, my lord.
The petitioner is apprehending arrest in connection with such and such case. As per the
Not
FIR.
arrested, anticipatory. Petitioner was not arrested.
So I'm saying that apprehending arrest.
Yes.
As per the FIR lodged by as per the FIR. Truck loaded with huge quantity of contraband ganja
180 kg.
was detained by the Ragada police, by the Gudari police. Stop. On interrogation of the driver and helper, it came to light that the ganja was allegedly procured from the present petitioner. Stop. There is no evidence to show the presence of the petitioner at the spot or of his possessing ganja in any manner. His implication appears to be entirely on the basis of the statement of the co-accused persons. Stop. As such, the ratio laid down in Tufan Singh versus so is squarely applicable. तापर आप कर दोगे surrender release on bail.
Item 51.
Each day appearance कर दो.
That one vehicle was intercepted. One Kumar Rana, he was apprehended with a vehicle. He disclosed that he procured ganja from and this petitioner. Babula Rana is the lordship running page 12. It has been granted bail. Babula Rana, running page 12.
Same order. Same order.
Item 52.
Apart from all other offenses, 307 is there. But there is no specific allegation against the petitioner. Some persons are there, they have assaulted. And ହାଣିଦେବୁ କହିକି ଡରାଡରି କରିଛନ୍ତି ଏବଂ ହାତରେ
severe brutally assaulted, my lord. Your lordship go through the
Yes,
Yes, I left on the case diary.
or your lordship made a first or second or parity.
Parity
One of the poets, Chittaranjan Sahu,
parity दे होगा. First or second or if you
has
want.
been directed to surrender, my lord, only. One Chittaranjan Sahu.
Parity. ଯଦି applicable ହବ, so applicable.
This court will not grant you parity.
Several injuries brutally assaulted, my lord.
Who is that? No specific allegation that the petitioner is assailant.
All right. That I will see. Affidavit case diary be obtained along with the
First or second.
along with the injury report for perusal of this court. List this matter on 12th September. No course of action. Pass over.
So item number 13.
Pass over 13. Okay. List this none appears for the petitioner on repeated calls. List this matter tomorrow.
So item number 32.
My lord, your lordship, kindly see the report, my lord.
What report?
The tax is
Mediation report. All right.
let's see.
नहीं 30 August को रहेगा.
Okay.
The report of the mediator indicates that the next date of the mediation proceeding is fixed to 30th of this month. Hence, let's this matter.
12 September.
On no, I have to get over about
19 September.
on 19th September. Is there any interim order?
Man.
Interim order to continue.
So item number 42.
My lord, on behalf of Chatui.
Yes, on behalf of Chato, what?
Passover.
For Israel.
Second.
No, let's this matter tomorrow.
Well.
Sorry. Stop.
Maybe party.
State is the party, lords.
Pathar matter होगा चले. Pathar होगा चले. नहीं Pathar matter hearing पे थी. प्रथम भी थी वो टॉप में. तो बड़ा को Pathar होगा चले. As a whole.
Well, verify if in the meantime the certified copy has been filed. That can't be also.
Pass over.
Item number 22.
Maybe. Item 22, your lordships, AD not back. Verify.
Up-to-date postal tracking report be tagged to the case record. Leave this matter next week. Then pass over. Orders matter is over. We'll take up the passover hearing matters. Passover hearing matter. Yes, item 1.
Yes, one, I have prepared the memo of citations and item 1. Item 1 tomorrow. My learned friend Mr. CORAM was conducting it halfway. He will conclude it by tomorrow. Yes.
All right. Pass over for the
I
day.
have also told Mr. Surya Prasad Mishra.
All right.
Item number 2.
This is that matter, my lord.
Yes.
We are prepared with the matter. My learned senior is on his legs. Can it be taken up tomorrow finally?
This what you say? But tomorrow there will be no further passover or adjournment.
We are prepared. We are prepared.
No, I'm not very much interested in your preparation. I'm very much interested in your submission. Whenever the matter is being called out, you are asking for a passover.
Last time also I have requested.
The senior counsel was waiting.
Lunch, lordship, we were ready. Before lunch, we were here.
You were ready.
We
You're
were,
talking in the past tense.
we were here before lunch.
Again, you were here. This is all in the past tense. All right, tomorrow. There will be no further adjournment or passover. There will be no passover, mind you. Yes. Item 3.
Item number 3.
Item 3. Yes. I think this was heard completely, probably.
Done is all submitted. Senior will answer.
You were to give a reply, Mr. Das?
Yes. Yes, yes. In this case, I have prepared those citations and a small note. Tomorrow I will be submitting. I have not made it in order.
Okay.
Tomorrow I will be submitting.
Tomorrow I'll close it.
Tomorrow, yes.
Passover.
Item number 4.
Well, on paper, yes, number tomorrow. I prefer tomorrow.
All right, passover.
Item number 5.
Sir, your matter. So upload is sir. मोर नोट थिला उधे मोर खाता लेखा Sir, you said you will take about 15 minutes. You said that you will take about 15 minutes. No, you had said that.
1.15 minutes.
So 1 point.
1 point.
So each point 15 minutes. I did.
Your lordship has formulated 6 numbers of substantial questions of law. So far as the first point is concerned, whether the plaint which has been signed, verified, sworn on oath and presented by plaintiff's agent Akshay Kumar Parija is maintainable when the said agent Akshay Kumar Parija has admitted in course of his evidence that he has no personal knowledge about the contents of the plaint, nor he has any personal knowledge about the transactions under the development agreement dated 7/8/2020, Exhibit A and Exhibit 8, and supplementary agreement dated 8/8/2020, Exhibit B and Exhibit 9 between the plaintiff and the defendant party.
This has been argued completely.
This has been argued. Case law has also been cited.
Yes, yes.
Now the second point is whether there is any cause of action for the plaintiff to file the suit, that is 1941 of 2021 on 14/9/2021 before expiry of the stipulated timeline for completion of construction of the proposed building project as specified under development agreement dated 7/8/2020 Exhibit A, Exhibit 8, which expires on 15/3/2025, and whether there is any cause of action for the plaintiff to file CS number 1941 of 2021 on 14/9/21 alleging inter alia non-payment of total consideration amount of the suit property to him before expiry of the stipulated timeline for completion of the payment by the defendant firm to the plaintiff as specified under the supplementary agreement dated 8/8/2020 Exhibit B, Exhibit 9, which expires on 15/3/24. Particularly when the plaintiff has already received rupees 3.20 crores from the defendant firm. This I will argue today. Now, there are three documents. That is, development agreement dated 7/8/2020 Exhibit A, Exhibit 8, and the supplementary agreement dated 8/8/2020, that is Exhibit B, Exhibit 9, and registered general power of attorney dated 3/9/2020 Exhibit 2. All these three documents are admitted documents.
Yes.
All these three documents the plaintiff Prabir Kumar Das has executed as the first part in favor of defendant firm as second part. Both the plaintiff as well as the defendant firm are signatory to these three documents. Now, I invite your lordship's kind attention to Exhibit A that is available in the
Yes.
internal page 4, clause 1. Clause 1.
Delo hard copy টা দাও। Hard copy টা দাও। যেতে করলে তো সময় সিওর করনা তো।
I will refer to three specific clauses.
ଆଗୁଡେ ଥିବ ଆଗୁଡେ ଥିବ ଅଛି
Exhibit A ଟା କାଢିଲେ ହବ, Exhibit 8 ଟା କାଢିଲେ ହବ. Both the documents are same.
ଏ ଖାଲି ଇଏ ଗୁଡା
ଅଛି
ଆଉ ଥିବ ନା
Internal page 4, clause 1.
କଣ ଏମିତି କରୁଛନ୍ତି ଜାଣିପାରୁନି ଏକ୍ସିବିଟ୍ ଗୁଡାକୁ ଇଏ କରୁନାହାନ୍ତି ଠିକ ଭାବରେ କଣ will send back the LCR to be prepared again. LCR ଗୋଟେ ତାଙ୍କର ଗୋଟେ exhibit exhibit A or exhibit Exhibit A. All right.
Then I guess. Internal page 4.
One bar. The marking, the arrangement of the LCR is by persons who do not know anything about law. So naturally, exhibit 8 barla, 5 barla. ଯେମିତି ସେଟ୍ କରି ରଖିବା କଥା ସେ ତ ଇଏ ନାହିଁ ବୁଝିଲେ ତ ଦେଖ ଏକ୍ସିବିଟ୍ 8 ପରେ ଏକ୍ସିବିଟ୍ D ବାହାରିଲାଣି ଏବଂ ଏକ୍ସିବିଟ୍ B ବାହାରିଲାଣି how can this very difficult. What is the corresponding number of the other exhibit? Exhibit A.
8. Exhibit 8.
All right. Development agreement 7th August 2020.
Madam. Kindly come to internal page 4, clause 1.
Yes, sir.
The first part, the landowner's allocation shall be limited to 50% of the super built up area up to the 4th floor.
Yes.
The actual allocation of a flat will be decided only after the approval of the building plan by BMC and registered by ORERA.
Yes.
Then kindly come to clause 7 at page 5. Six months from the date of final approval of building plan by competent authorities, unless prevented by reasons beyond his control of the developer, that is earthquake, civil commotion, strike, riots, and litigation, rationing of cement, steel, rod, etc., required for construction. Then kindly come to clause 14.
Yes.
Here, if your lordship looks to clause 7, the timeline for completion of construction is 36 months plus 6 months, 42 months. That is from the approval of the building plan.
Yes.
Then, the first part, landowner, clause 14. Next page, Raj. Internal page 6.
Yes.
The landowner acknowledges to have received a sum of rupees 2.80 lakhs only by bank deposit. 2 crore 80 lakhs only by bank deposit in favor of plaintiff Pravir Kumar Das, standing at Canara Bank, Sahidnagar branch, Bhubaneswar, and Axis Bank, Satyanagar branch, Bhubaneswar, on multiple dates as per details. The details have already been given in the tabular form under clause 14. Now, if these two deadlines, timelines are calculated, your lordship will see that your lordship will see that both the timelines, the first timeline for construction expiration,
So it's 36 months from the date of final approval of building.
final approval. Approval of the BMC has been obtained on 16/9/21.
16/9/2021.
Minor.
Yes. So say the 36 plus 6 months.
36 plus 6 months. So also, now, on the next document, that is Exhibit B, Exhibit 9.
Yes.
For allocation of share between developer and the landowner. Internal page 2.
Yes.
Fourth subparagraph, fifth subparagraph, sixth subparagraph. Last three subparagraphs may kindly be seen.
Last three subparagraphs of the
same document.
Yes. You have consideration value of 50% share of each.
Minor. The construction value of 50% share, the considered built up area, carpet area, inclusive of parking and undivided share of common area will be limited to 15 crores, 15 lakhs only. So the first document 50% up to 4th floor, they alter by this document. They will only receive the quantified by in terms of month. 15 crores, 15 lakhs. Then fifth subparagraph. The first part landowner authorizes the second part, builder, cum developer, to dispose of the units, flats in the proposed housing project of the property and deposit a sum of rupees 15 crore 15 lakh only in his bank account after adjustment of the security money of 2 crore 80 lakhs only already received as security in terms of the development agreement dated 7/8/2020. So he acknowledges to have received 2.2 crore 80 lakhs under the development agreement, as well as in the supplementary agreement. Then sixth subparagraph. The balance amount of 12 crore 35 lakhs only will be deposited within a period of 24 months with a grace period of 6 months from the date of approval of registration of the project by competent authority, that is BMC and ORA. I have already given the approval date by BMC.
Yes.
Now, on 18/8/2020, Exhibit H.
Exhibit
H.
That corresponds to? Does it correspond to any other exhibit?
No.
Exhibit H. Acha.
The ex-managing partner was living then. He subsequently died December 21, 20. Mr. Vibhuti Bhushan Patra, the then managing partner of the defendant firm, deposited rupees 63,949.85 with BMC towards demand notice for building permit application.
Yes.
With reference to ANB 200401. The said fee receipt BMC has been marked as Exhibit H.
Yes.
Then, to make necessary application to BMC as well as Orera, a general power of attorney is required, which transpires from Exhibit 2 to be executed by the landowner plaintiff in favor of the builder developer, that is the defendant firm. On 3/9/2020, the landowner plaintiff Prabir Kumar Das executed a general power of attorney in favor of defendant firm represented through its managing partner Vibhuti Bhushan Patra to fulfill the earlier agreement dated 7/8/2020 and 8/8/2020, internal page 3. The said GPA has been registered in the Office of Sub-Registrar Khordha, BBSR, on 3/9/2020 by Exhibit 2. I invite your Lordship's kind attention to Exhibit 2, GPA.
Yes.
If your Lordship looks to page 3.
Page 3. Yes.
Second subparagraph.
Yes.
Under the scheme of the aforesaid development agreement dated 7/8/2020 and subsequent supplementary agreement dated 8/8/2020, I, the executant principal, hereby execute this power of attorney in favor of the above named attorney holder to fulfill the aims and objectives enumerated in the aforesaid development agreement dated 7/8/2020 and subsequent supplementary agreement dated 8/8/2020. Now, the said GPA has been registered and the total expenditure is 54 lakhs. Including stamp duty and incidental registration fee, etc., etc.
Yes.
Now, that has been borne by the defendant firm. Now, the defendant firm paid and the plaintiff respondent received through his Axis Bank account via check number 047013 dated 20/10/2020 an amount of rupees 20 lakhs. This is in addition to 2,80 lakhs already received under the development agreement. Similarly, this has been received on 7/11/2020. Now, the defendant firm paid and the plaintiff firm received on 4/12/2020 through Axis Bank via check number 047014 dated 30/12/2020 an amount of another 20 lakhs. Exhibit 4 last page, Exhibit C last page. Hence, your Lordship,
Yes.
yes,
Bank statement.
my lord. Hence, the plaintiff has received total sum of rupees 3.20 lakhs out of 15 crores, 15 lakhs. These two transactions are available to your lordships in the statement, Exhibit 4, last page. 7, 11, 20 and 4, 12, 20.
Yes.
Fine. Now, on 14/12/2020, managing partner Vibhuti Bhushan Patra expired. The certificate is available to your lordship under Exhibit E.
Exhibit E. Anyway, so that is not disputed.
That is not in dispute. But all the unwanted things happened only after the death of Vibhuti Bhushan.
Yes. When did he die?
On 14/12/2020, Exhibit E.
ये सीरीज टाକୁ ଠିକ ଭାବରେ ରଖିନାହାନ୍ତି ତ ସେ ଜାଣିବା କଷ୍ଟ ହଉଛି ଏନିୱେ ଏକ୍ଜିବିଟ୍ ଦିଟା ପଛରେ ଆସିବ ଖବର ସଜାଡିଛନ୍ତି ଦିଟା ପଛରେ ଏମ୍ ପି କ୍ୟୁ ଆଗରେ ଏକ୍ଜିବିଟ୍ ଇ ଆଇ ଗଟ୍ ଇଟ୍ 18/12/2020 डेट ऑफ रजिस्ट्रेशन डेट ऑफ डेथ इज
14/12/2020
14/12/2020
Certificate of death
Yes.
is given.
He is the managing partner.
He was the ex-managing partner. After his death, the partnership needs to be reconstituted under law.
Yes.
And on 5/1/2021, filed Exhibit F, the deed of reconstitution of defendant firm, Messrs. Creative Builders, was executed between continuing partner, the widow of Vibhuti Bhushan Patra, his daughter, and Rajalakshmi, and his son.
It is exhibit?
This is Exhibit F.
The deed of reconstitution.
Mine.
Yes, exhibit F.
You saw the document?
Yes, yes. Nirupama Patra and Rajalakshmi Patra.
Rajalakshmi Patra and the son.
Rajat Kumar Patra.
Mine. Kindly look, just below Nirupama Patra, it has been mentioned continuing partner. He was previously the partner and also continued under the reconstituted partnership and became the managing partner. Now, BMC, by its letter number 2217 dated 13/1/2021, intimated defendant firm regarding approval for construction of proposed B plus S plus 6-storied MIG residential apartment building over the suit property in the second DP and BP committee meeting, subject to compliance of the following 6 documents. This is available to your lordship under Exhibit J, dated 13/1/2021. Your lordship got it? The 6 conditions required to be fulfilled. I think your lordship has got it.
No.
Kindly see
Exhibit J, yes.
Exhibit J. These 6 conditions are enumerated below.
Yes.
Recommendation towards fire safety, NOC from PhD, external infrastructure development plan, structural vetting of building plan by the civil engineering department of any government engineering college located in Orissa, requisite number of recharging pits for rainwater harvesting. Then 6 is submit an affidavit to the effect that the houses shall be allotted to MIG category people. Then Odisha Fire Service, kindly come to Exhibit K, dated 5/2.
How is it relevant, sir? How is it relevant?
This is relevant for the purpose that the time consumed in the process was on account of these requirements.
Yeah, that's all right. But the thing is, you have mentioned initially as per that agreement, final approval 36 months plus 6 months. So the approval was obtained on 16/9/2021. So 36 months is 16/9/2024. And 6 months is 16/3/2024. The suit was filed before that. That's all right. Other also.
And payment also, the suit was filed before the completion of timeline.
I think the point is taken. We need not go into that detail.
Both the courts below has said that these documents are beyond pleadings, therefore they did not take into account, and turning down my contention, they have allowed the suit as well as the appellate court allowed the appeal.
No.
They dismissed the appeal.
What is your response to that finding that it is beyond pleadings?
I have indicated it all in the letter communication as well as the written statement.
Yes, that is what I want. Whether there is a specific pleading.
It is available in the plan. In answer, it contains finds place in my written statement as well as in the communications.
So it is not, you mean to say that this finding is not erroneous? It is
These findings are erroneous. That's all. Then, register of firms, these are the subsequent Exhibit G, Exhibit M, Exhibit N. These are, I have provided all the documents obtained from different authorities.
To show the delay.
To cover up the delay. Exhibit G.
Yes.
Then kindly come to Exhibit 5. Letter dated 21/7/2021.
Yes.
Srimati Nirupama Patra, Managing Partner of the defendant firm, by letter number 124 dated 21/7/21, intimated to plaintiff Pravir Kumar Das about sad demise of the managing partner Vibhuti Bhushan Patra, reconstitution of the defendant partnership firm. In the said letter, it has been mentioned the new management has accepted. Second paragraph, last line.
Yes.
The new management has accepted in principle to honor all the official agreements signed and executed by our former managing partner, late Vibhuti Bhushan Patra, in letter and spirit. We are also committed to pay the amount due to you as per the terms of the conditions of the aforesaid agreement signed between you and our firm. However, we will try and may pay off your share even earlier, depending on the financial situation of the firm. Last sentence. Expressly specifically we have mentioned, we will try to pay your dues even earlier to the timeline of payment. This has been taken by both the trial court as well as the first appellate court, that I did not comply with the conditions of the agreement. Now, Exhibit 6. This is plaintiff's reply to my letter. He says that you have failed to obtain necessary permission from the competent authority for completion of the project. Paragraph 5.
Yes.
Internal page 2.
Yes.
First of all, I want to intimate you that BMC by its letter number FA has directed to comply with the necessary requirements as per the decision taken in second DP and BP committee. I have referred to earlier, and I have answered that I have complied with it. But till date, no action has been taken from your side for obtaining permission. Even I came to learn that without obtaining ORERA registration certificate, you are collecting huge amount from the interesting purchasers by advertising the project, which is complete violation of the rules and regulation prescribed by ORERA, which is absolutely wrong. Such questionable, illegal and unconscious mechanism of your act will not only and will put not only your project into litigation, but I will be dragged without any fault of mine to such litigation, which will cause immense hardship to me. The possibility of the land getting attached due to multiple litigation is not ruled out. These are absolutely imaginary things. Nothing has happened in course of the transaction. Now, then paragraph, just before paragraph 7, your firm is under a lawful obligation to pay the rest amount of rupees 12 crore 35 lakhs within a period of 24 months, with a grace period of 6 months from the date of the approval of registration of the project by the competent authority, that is BMC and ORERA. It does not mean for an indefinite period your firm at its own will and wish will obtain the required permission, and thereafter I will be counting the date for getting the money as per our agreement. But fact remains that prior to this, within this short period, before, by the time they finish 80 lakhs plus 20 lakhs and 20 lakhs, 40 lakhs, 3 crore 20 lakhs. Now, the defendant firm, by its letter Exhibit 17/8/2021, The delay caused was on account of various reasons beyond their control. Sad demise of Vibhuti Bhushan Patra and reconstitution of the partnership firm with register of firms. Reorganization of the firm was only possible after due recommendations from the state secretariat. On account of COVID restrictions, most of state offices were either not functioning or functioning with a skeletal staff for emergency work only, and entry to office were restricted. And D, at no point of time we have tried to intentionally delay the project. After all, any delay is also a loss to our firm. E, the expenditure incurred by you for conversion of the leased land to freehold has been made by you after taking security deposit from us. With respect to allegations of impossibility situation, the defendant firm explained. Next page. No construction firm can start executing the work without obtaining the required approval. And these conditions also existed in the original agreement signed between us. We are very much optimistic that we shall pay the agreed amount before the scheduled timeline. We have just received a communication from BMC where they have requested us to deposit a sum of money before issue of approval letter, which are likely to do next week. With respect to the allegation that defendant firm has not taken any action for obtaining permission from BMC, in compliance of BMC letter dated 13/1/21, the defendant firm explained to the effect, in fact, all the required documents have been obtained and submitted to BMC. It is only after our submission BMC has finally asked us to pay the development fees. Paragraph 5, if your lordship.
Yes, I've seen it.
Okay. Then, to allege that no action has been taken from the side.
Sir, I think this point is taken. We cannot go into all these details in a second appeal.
No, I am not. I am just appraising your lordship.
All right, sir.
Unless your lordship.
Your point is, as I understand, there are two things. Whether he had a cause of action.
Minor.
According to you, it's a premature action.
Minor.
You have given
the date,
down,
2 dates.
I have taken down the dates. I have also calculated myself 36 months I have calculated the dates.
Minor.
I don't think we have to go into all these details.
No.
I have also taken note of your submission that some of the.
What I beg to impress upon your lordship's judicial consideration, that at no point of time there is any attempt to delay the payment.
Yeah, that's all right. That's all right. That point is taken. But then again, that would be a factual finding. Why should this court interfere?
Yes. Or denial of payment.
No, that's true. So I think
I have given the 2 deadlines your lordship has
noted.
Therefore, kindly come to Exhibit P dated 25/8/2021. That is BMC approval.
Yes.
Kindly match it with the 2 dates your lordship has taken note of.
Yes. This is 25/8/2021.
21.
Yes.
Whereas the digital sign has been accorded on 16/9/2021.
Yes.
Last page.
That will be the date of it.
That is the actual date. Now, we have made payment under Exhibit P to BMC 64 lakhs 72,509.
Yes.
Available under paragraph 15.
Paragraph 15 of
Exhibit P,
Last page.
last page.
yes, yes.
Now, thus, not only we have paid substantial amount of 3 crore 20 lakhs to the plaintiff, but also we have spent around more than 2 crores on towards these official expenses. And registration of power of attorney. Thus, a substantial interest has been created in favor of the defendant appellant firm.
Yes.
This suit was filed on 14/9/2021. What I beg to impress upon your lordship is the 2 dates your lordship has noted down is yet to come.
Yes. One is 16/9/24, another is 16/3/25.
25. By 24, the payment is to be completed.
Yes.
Before 24, I have already paid 3 crore 20 lakhs. But the suit has been filed on 14/9/2021. Therefore,
the suit is premature according to you.
yes, there is no cause of action and the suit is a premature one on the date of presentation of the plaintiff. Now, then
I think that should be all for this ground.
Yes.
This question, second question, that should be all.
Yes.
We'll take it, continue tomorrow.
Yes.
Other matters are there, continue tomorrow.
By these substantial question number 2 and 3, as well as 8 is, which your lordship has framed, that is covered.
Yes, I have already indicated it earlier.
Please, yes. We'll continue tomorrow.
Yes.
No, we could have continued, but other matters are there.
No.
ଆଗ ଆରମ୍ଭ ହେଇଛି D, ତାପରେ P, ତାପରେ ଇଏ ଏମିତି ତ କିଏ talking କରୁଛି? Lower court ରେ. You ask the registrar judicial to meet me today.
ଆଗରୁ କଣ ଥିଲା କି ସେ ଯୋଉ ରିଟାୟାର୍ଡ ଆମର ସିଭିଲ କୋର୍ଟ ଷ୍ଟାଫ ସେମାନେ ଡେପୁଟି ହଉଥିଲେ ଏଲସିଆର ଟାକୁ ମାନେ ଯେମିତି ରଖିବା
ଆପଣ ଦେଖ ନିଜେ ଦେଖିବେ D ରୁ ଆରମ୍ଭ ହେଇକି ତାପରେ P କୁ ଯାଇକି ହଠାତ୍ ପୁଣି ବୁଲିକି ଆସିକି A କୁ ଆସିଲାଣି।
ସେଇଥିପାଇଁ ସେଟା ଇନ୍ ଅର୍ଡର
କେମିତି ଆପଣ କହିବେ ତାର ଗୋଟେ ମେଥଡ ଅଛି କେମିତି ସେ ସିଭିଲ କୋର୍ଟର ସେ ଶିରସ୍ତାଦାର ମାନେ they are experts in that field.
ସେଇଥିପାଇଁ ସେମାନଙ୍କ ଦରକାର ହେଇଥିଲା
unnecessary time is being wasted. ଖାଲି ଖୋଜିବାରେ ଡକ୍ୟୁମେଣ୍ଟ। Sir, we'll continue tomorrow.
Right. After lunch?
Sir, obviously after lunch. I think tomorrow you will complete.
I will try. Because the 2 substantial questions have gone.
2 na 3 basic wala?
3. No, dita gala je so premature ta bhi is covered within this.
No, premature
ଆଗରୁ ଯାଇଥିଲା ଗୋଟେ ଆଜି 3ଟା ଚାଲିଗଲା
ଆଜି 2ଟା ଗଲା। ନାଇଁ ଆଜି 2ଟା ଗଲା।
ନା ବିୟଣ୍ଡ ପ୍ରିଡିଂ ବି କରିଦେଇଛନ୍ତି ନା ଆପଣ?
ନାଇଁ
ରୁଟିନ।
ତେଣୁ ଆପଣ ଡିସାଇଡ କରିବେ ମୁଁ କେତେ ଦିନ ନେବି ଆପଣଙ୍କର କେତେ ଦିନ ପରେ।
ଆପଣ
Yes.
Item number 6.
ଏଲସିଆର ଟାକୁ ଟିକେ ସଜାଡ ମାନେ ଘରେ ଏତେ ଯାଉଛି ବୁଝିକି ସମୟ ବାହାର କରିବାକୁ। Yes, what is this, Mr. Mahathi?
That landlord tenant matter.
Yes.
Are almost covered, but I am to recapitulate only.
Oh, there were 2 agreements, one was stolen and all that.
One, yes.
That's remember. No, your second appeal was whether the lower appellate court was correct in not considering the additional evidence ought to be adduced by the appellant during despite referring to it in the judgment. Yes.
Yes, one aspect, I had already submitted that there is no dispute to the relationship at least. The dispute was with regard to non-payment and the existence of which agreement. On the first occasion, the plaintiff in his plaint started with a story that the original agreement was torn and the pieces were handed over to him. No date was mentioned. Plaintiff is silent about the date on which the agreement was torn. So the plaintiff avers that I prepared after collecting the torn pieces, I restored the agreement and that is being filed, that is Exhibit 1. Now, the learned trial court decreed the suit with the prayer to pay 4 lakhs rupees as monthly rent. That is heavily under dispute. I prefer appeal. In appeal,
it was 1 lakh.
1 lakh. In appeal, in fact, the documents are called for. I got the documents from the RTA under the RTA Act from the GST authorities, where a copy of the agreement was there. So the date was very much material. Therefore, I was referring to, because it is not there in the plaint, the relevant date. I was referring to Exhibit 9. Let me kindly again have a glance at Exhibit 9. Exhibit 9.
I'm now afraid of, trying to find out exhibits.
Okay.
I had seen it on that day.
Yes, I'm just passing on the certified copy.
Better, please.
The date is available at para 5. It is of the year 2020. Date is available.
Date of the agreement?
No, the date when the tearing is the agreement happened, because it is there. After that, it is submitted. Kindly have a glance. Para 5.
Showcasing their money and muscle power by hiring Gunda and showing pistol knife. It is threatening video.
2020. Before that, at least the agreement was intact. Wherever it may be. It may be with me, it may be. But I filed the application for additional evidence. Along with the application for stay, I have submitted the agreement. Kindly have a glance. I was on that day also, I was referring to that.
Some annexures. 1, 2, 3, 4.
Yes. Annexure 2 is there. Annexure 1 is the
Annexure 2 is that GST.
Annexure 1 is the copy of the RTI.
But Annexure 2 is the GST.
And yes, Annexure GST. This Annexure 2, kindly have a glance when it was filed before the GST authorities. This is much prior to validity from 18/10/2019 to date is not given. But the validity period started from the year 2019.
This was supplied to you under the RTA Act.
RTA Act, Annexure 1, page 1.
Because it doesn't say period of validity from to kete jaye sida nahi.
That is that. Yes. Under the RTA Act, this agreement was supplied. But this is the certificate under the GST. The agreement date. Same. Second September 2019. Effective date is October 2019. From page 8 of that application.
Agreement. Yes.
That is agreement.
Yes.
Just the previous page under this letter under the RTI, it was supplied. This letter is from the GST authority also. So the date is effective date is from 1st October 2019. Agreement is still valid at least till end of the next month, because it was for 5 years. There is no dispute to it. Now, the next page of the agreement, page 9, last lines, 2 lines.
1 lakh.
Monthly rent is 1 lakh. Now in the torn agreement, exhibit 1, the monthly rent is 4 lakhs. So which is to be considered as the genuine one. Now this document was obtained under the Right to Information Act from a public authority, and the exhibit 1 was submitted by the plaintiff herself or himself. This document was filed along with the payment details also, that will become later, along with an application for acceptance of additional evidence. Now kindly have a glance at the appellate court judgment. I was also on that date. Page 22. Page 22. Learned Lower Appellate Court has taken note of my submissions that such a document is filed. In order to harass the defendant about 9 to 10 lines from the top.
Yes, I've seen that, but what happened to the petition? Did he pass any order?
That is exactly in the last page. Kindly have a glance at the judgment. No reference elsewhere. Last page of the judgment.
Yes.
Last page. The last but one paragraph. Any other applications, petitions pending in the appeal are disposed of accordingly. This is the conclusion. No discussion, consideration regarding this document, whether it is necessary, not necessary, or anything else.
So we are only on the limited point of
non-acceptance judgment is valid.
But 4127 application.
Because the application has not been disposed of, has not been considered at all.
Yes.
Series of judgments are there. I need not show it.
The only question is that the substantial question of law has been framed because he has questioned the decision on the ground that the petition under Order 41 Rule 27 was not taken into account. What is your response?
Milord, prior to going to that, I have the honor to submit before council that this RSA 179 is against a concurrent judgment. As on today, 5.52 crores lies in the tenant, and I have not got the part security money of ₹8 lakhs as on today. And they are telling that the agreement is still subsisting. Unregistered agreement covering a period of more than 1 year is to be treated as a rent month to month basis. And right from the very beginning, they have not paid a single month rent as yet. Even not the part security money of ₹8 lakhs. And by that, when the matter is taken up to the governor, the Milord, exhibits before going, I have made this entire file for your lordship. So 52 pages already exhibit ହେଇଛି ଆହୁରି ବହୁତ ଗୁଡ଼ା exhibited ହେଇ ରହିଲା କାରଣ ନିଜେ ଟ୍ରାଏଲ କୋର୍ଟ କହିଲେ ଯେ ଏତେ ଡକୁମେଣ୍ଟ ଦେବା ପରେ ସଫିସିଏଣ୍ଟ ହେଇଗଲାଣି ତେଣୁ ଇଟ୍ ଇଜ ଷ୍ଟିଲ୍ ଦ୍ୟାଟ୍ ଇନ୍ ଦ ଏଲସିଆର ଫାଇଲ୍ କିନ୍ତୁ ଫର୍ଚୁନେଟଲି ଅନଫର୍ଚୁନେଟଲି ସେ ପାର୍ଟଟା ପୁରା ତଳ ଟ୍ରାଏଲ କୋର୍ଟ ଫାଇଲରେ ଟିକେ ଆସୁନି ଓନ୍ଲି ଆସୁଛି ଇମିଡିଏଟଲି ଲାଷ୍ଟ କୋର୍ଟ ଅଫ ଫାଇଣ୍ଡିଂ ଫାର୍ଷ୍ଟ ଆପ୍ଲାଏଡ୍ କୋର୍ଟ ତେଣୁ 52 pages donne court master pesca they are a part of the court. I am not going to find out a flaw in the court as they are doing. They have already gone to the facts finding. It is this high court is meant for law finding, not facts finding. So, Milord, in between the 11 number, 11 and 10, in between, that is total 52 pages about entire activity I have got. I don't know whether they are showing it or not. So, the FIR lodged on dated FIR dated 6/11/20 is the very much there in the entire file. Milord, the court must be pescar sleep କରି 52 already exhibition ହେଇଛି ତେଣୁ it is not that a big mistake for which governor representation ଆପଣୁ governor representation ଉପରେ shipping
ମୋ question ଟା ବୁଝନ୍ତୁ ତାର answer
4127 ଆପଣ ଖାଲି କରିବେ yes 4127 it is not at all entertainable. Hi Milord, kindly refer
where the court has said that it is not entertainable.
Court has never. I have not told. The court has a very.
No. You cannot supply reasons. The court must say. If the court has said that it is not entertainable, then only you can support that decision. Court has not said anything. It has not considered. The court, a petition has been filed. The court is to pass an order. The Order 41, Rule 27 is always filed at the appellate stage to adduce additional evidence. The usual practices, it is dealt with along with the final hearing and it is dealt with in the judgment. এই ডকুমেন্টটা আমি admit করলো at the stage of appeal. He has said nothing about Order 41, Rule 27.
मिलर जो ऑब्जेक्शन जो पिटिशन फाइल करजंदी काइंड ऑफ हैव ए ग्लांस तार मो जो ऑब्जेक्शन के लिए रिसीव करची
Sir, court.
नहीं माय ऑब्जेक्शन इज देयर बिकॉज़ बाय
Your objection is there, but there is no order to that effect by the court.
by that time they are not file any agreement copy. The copy also not served to me.
No.
Miller just kind of have a glance there.
Only thing is that, you see, this court, if this is what has happened in the court below, then the matter has to be considered by the court below again. He has to pass an order on the 4127 petition along with the judgment. He has to take into, he may reject it.
Miller, prior to that, my honest question. Miller, जो stay petition सेटर काई immediately ये थी because they insisted for immediate hearing on merit. Because when I insisted for 4105 Miller, it's a mandatory to make the payment of the entire amount. So to avoid that, so I'm hearing Miller right now, but then I'm hearing Miller within 2 months the case has been disposed of. And then under Part 7 in the IAD file, the court has when the court has decided to make the hearing on a merit. So court hear merit court or judgment running page number 16 RSA page number 29. Court has very specific and very beginning from where perusal is apparent that the
LCR is to order sheet just
giving highly limit for me. From where perusal started with the work.
When did you file the petition? 4127?
Application for additional evidence.
Yes. That is the only ground on which this appeal has been admitted.
Exactly.
Not much. Much.
Order sheet देखा था? You filed it on 15/3/2024.
March 2020. March 15/3.
15/3?
Yes.
Letter order
Yes.
Was hearing gala. Case record along with LCR is received on transfer gala. Learned advocate for the appellant petitioner files an application under Order 41 Rule 27 of CPC praying to accept the documents as per list taken on record as additional evidence gala.
Thereafter transfer to other court. Thereafter hearing the
The advocate for respondent also files objection to the grounds raised in appeal memo and cross-examination to RFE. Grounds, objection to the grounds raised in appeal memo? He may have filed something.
Yes. Se oda appeal ro oda reply dejan jota ki lakha hai. Normally
is not necessary, but then he has put up for judgment.
Yes.
In the judgment, he has not referred to 4127. Very simple matter, Mr. Korav.
My point is not there.
But my point is that. And it is my point which matters.
Definitely. You approach it.
No, apology. It is my point which matters.
Kind of see the agreement that exhibit. Does that contain the signature?
Don't worry. Your matter will be heard again. But this 4127, he has to pass an order. If he wants to reject, he may reject it citing appropriate reasons.
Kind of only a copy or some documents.
Sam.
Sir, it contain the signature seal of a.
Yeah, let him consider that. You raise your objection there.
I forgot
which is reasonable.
This is power of the court. Whether they will enter not.
Court মানে কিছু অর্ডার বি পাস করিবেনি কোর্ট কোর্ট পিটিশনটা রেকর্ড করিবে কিছু অর্ডার বি পাস করিবেনি
court petition word will nowhere it is mentioned. Learned trial appellate court has not mentioned anywhere it is a petition. Only simply the documents.
All right. I'll pass on.
Documents obtained under RTI. What is this? Documents obtained under RTI reveals the appellant number 1 has filed an agreement signed between the parties Milord, documents, no one of petition anywhere, signed between the parties with the illicit bill, depicting the name of the pro forma defendant on it. So the word very word petition, it is nowhere it is not mentioned. Milord, judgment is very beginning. Milord, judgment is bare simply exhibition turn on to simply Milord page number kind just go page number 6 RS page number 59. Milord, from bare page perusal, the rent agreement produced by the plaintiff is found to be absolutely genuine and correct. After 5 years, they have stressed this with their spurious objection. 5 years they have dragged the case without making the payment. Milord, it is sorry when they are presenting. It was around 437. I have told the number. Milord, why I did? I
not referring to the substantial question of law at all. Substantial. You are going on going entirely off a tangent.
Milord, 11 numbers of citation I have brought.
Sir, I will not indulge you. But it will take some time. That is why.
I will not take anything.
What time? You have already completed your argument. 4127 ऊपर आपनको बारंबार मैं कहूँ आपन कहंतु बोली आपन को नदी ता ऊपर
4127 मिलड़ 4127A 4127A को जति जो
आपन तळ कोर्ट ऑब्जेक्शन फाइल करछन 4127 रो
is
because you have not filed any objection. You have filed an objection to the grounds raised in the application.
Filed the objection.
When did you file, sir? When did you file?
Courier.
Did you have a copy? Do you have a copy of that objection, sir?
23 मिनट से मतलब courier copy कर 23 objection देखिए
देखिए I may have missed. No, let me check. I may have missed it also, but what I found that you have filed objection to the grounds raised in the appeal, yes, not to the 4127 petition. The appeal like upon well another you are not interested. You are not supposed to file any. You are not required to file any objection to the grounds. 15 days से file करे 15/3.
Copy I'm asking them.
23. I am answering it because it is mentioned in the court document. A copy of petition under order 41 is served up with objection. Put upon it for objection at hearing. Yes, he has filed objection. He has filed objection. On 23/3 he has filed objection.
সেটা বলতে আমি কপি দেই না
Yes, he has filed his objections on petitions dated 12/2/2024. That is another petition we are not concerned. On 15/3/2020 of petition dated 15/3, which is order 41 rule 27.
Yes.
That he has filed an objection. So he, in addition to that, he has filed the objection to the grounds of appeal.
Yes.
Chalo. Sita chalo. Then he has heard and then 1 or 2 dates he has posted for judgment. Judgment does not say anything about this petition.
That very word petition is not there. Miller, 4-5 page खाली LCR file देखे it is sufficient.
नहीं मुझे देखी नहीं.
खाली LCR.
नहीं मुझे देखी नहीं.
Miller related.
नहीं, मोटे नहीं. Court, the second appellate court is not a fact-finding court. It will not enter into all these factual controversies. The court will find whether a proper procedure has been followed or not. This is the substantial question framed in so far as this case is concerned.
We have filed objection.
You have filed an objection. It has not been considered. Neither his petition has been considered, nor your objection has been considered. He has not passed any order. He straight away gone on and has disposed of saying any other applications petition pending in this appeal are disposed of accordingly, as if it's a writ application.
Miller Supreme Court, so clearly mentioned, court is not bound to accept it, and
so he should have rejected it. He is not bound to accept it. Who says so? He is bound to. He is, in fact, he is not bound to. He should have rejected it.
Discretion power conferred on the court by the
discretion किसी न था ये. He should have rejected it by assigning proper judicial reasons. He has not done that. Now he will remit it back. He will again consider that application, and that's all.
But
simple কথা.
But Miller, it is the highest court of this one. So kindly just ask them to make the payment.
No, it will be open to you to file that application before the court below.
But this is the highest court.
So you can make that way. You have already filed an execution case.
No, Milord, when they are
You have, sir, you have already filed an execution case, haven't you? You have filed an execution case?
they do not have stayed.
Yes, yes. It has been stayed.
So immediately let it be back.
So,
Milord, 19th ରେ ତାଙ୍କୁ ପୋଲିସ ଆସିକି ବେବିଲ କରିଥାନ୍ତା 19th date was fixed କିନ୍ତୁ 18th ରେ ତ stay କରିଦେଲେ
all right. I'll pass order. Don't worry, I'll pass order.
kindly vacate this stay out please.
All right.
କାରଣ ମୋର already ସବୁ ଜିନିଷ ନେଇକି ପଳେଇଛି ଯୋଉ କହିଥିଲେ ଢେଙ୍କାଳକୁ ଢିଙ୍କିକା ଦେଇକି ଢିଙ୍କିସାରୁ ପଠେଇଦେବୁ ମୁଁ ଢେଙ୍କାଳିଆ ବୋଲି ମୋତେ ପତ୍ର ଦେଇ ମୁଁ ଇଏ ପାଇବି ନା ମୋ ଟଙ୍କା ହଉଛି ମୁଁ ଆଜି ଟଙ୍କାଟେ ପାଇନି
ଢେଙ୍କାନାଳି ହେଲେ କଣ ହେଲା ସାର୍?
ମତେ ଏଫଆଇଆର ଲେଖିକି ଦିଆଯାଇଛି ଆମେ ଲୋକ କହୁ ଢେଙ୍କାଳିଆକୁ ଢିଙ୍କି କାନ୍ଦେଇକି ଢିଙ୍କିସାରୁ ପଠେଇଦେବୁ ତେଣୁ ହି କେମ୍ ଭାଇଲେଣ୍ଟ ନା ଆଟାକ୍ ହାଉସ୍ ଫର ହୁଇଚ वी आर नॉट एबल ଆଇଁଷ କୋଡେ ମିଲର ସବୁଠି ଡକୁମେଣ୍ଟସ ଦିଆଯାଇଛି।
ଆପଣ କେତେ ଦିନ ଓକିଲାତି କଲେଣି?
ନାଇଁ ମିଲର ଆଇ ୱାଜ ନାଲକୋ ଏମ୍ପ୍ଲୟି 65 ଇୟର୍ସ ମାସିକ ଯେହେତୁ ଗୋଟେ ଟ୍ରାଏଲ କୋର୍ଟରେ ବହୁତ ହ୍ୟୁମିଲେଟ କଲେ ମନେ ମନେ ଓକିଲ ତାରାପୁର ଗଣନାଟ୍ୟର କଳାକାର ଏମିତି ହେଲେ ହଜୁ କହିଲେ ଢେଙ୍କାଳ ଆସିକି ଏଠି ତାରାପୁର ଗଣନାଟ୍ୟର କଳାକାର ଯେତେବେଳେ ହଜୁର ଇଏ କଲେ ଆପଣ ତ ବୋକାଟମ କଲେ ନାଇଁ ପାୱାର ଅଫ୍ ଅଟର୍ନ ଦେବାକୁ ପଡିବ ତେଣୁ when you are appearing person
ଲାଷ୍ଟ ଅପିଜନରେ କଥା ହଉଥିଲା ଯେ advocate ହିସାବରେ appear କରିପାରିବେ he can do his own case for
for his wife.
White cover record ରହିବ
Shri Koro files general power of attorney executed by Subhalakshmi Mishra. The respondent number 1. Respondent number 1. The same be kept on record.
Item number 8.
Item 8, I am for the respondent, Your Lordship.
Who's for the petitioner? You are for the petitioner?
My lord. Yes. Item 8, my lord.
Your Lordship,
I have filed the substitution petition, my lord. IN number 30 of 2044.
What letter your client has written some letter to the registered judicial?
My lord, you just transferred the issue.
Okay. So now this is why has it come?
Your Lordship, this is
the substitution petition. So my lord, appellate
substitution kahin?
Appellate
IE tag number ta kon to ye?
30 of 2024. 30 of 2024.
301, Your Lordship. 301. Your Lordship, I have a
301, yes.
Submission to made, Your Lordship.
Yes.
Your Lordship, I have to file objection to this IA for the reason that as per my instruction, that sole appellant, he died unmarried. He has no legal heir, Your Lordship.
Okay.
So, Your Lordship, I have to file an objection. I have also asked the client, he is actually currently residing in Hyderabad. So, if Your Lordship may kindly take it up on second week of September so that I can file the objection to the IA.
Right.
And Your Lordship can hear objection along with this IA, Your Lordship.
Learned counsel for the respondents request for an adjournment in order to file objections to the petitions filed by the appellant for substitution of respondent number?
Respondent number 1, A and B, Your Lordship.
Respondent numbers 1, bracket small a, and 1, small b. Is this matter?
So we commencing 17th September.
In the week commencing 17th September, objection if any be filed in the meantime.
Obliged.
Item number 9.
I will beg your lordship to issue notices on the respondents who have not been served on them.
1 to 3.
There is here 1 to 3 in the first case, and in the second case, respondent number 6 and 7.
There are 2 matters.
There are 2 connected appeals.
So notice was issued.
2 suits, 2 are first appeals, and 2
take fresh notice.
Fresh.
If
your lordship so desires, I can take notices by special messenger.
Why special messenger? What is the urgency?
The urgency kon se second appeal ta janile tagere se amo jaga ku phale neikri mari bosi ki 8 varsh position roikri kaduna dada ka sangare compromise kariki lokala before admission of a suit the suit was compromised in lokadalat. When I challenged, the learned trial court decided, but the learned appellate court decides, you being a grandson, how can you inherit the property of your grandfather when your father is alive?
Okay.
So that is the only point on
Anyway,
this.
so take notice of
As your lordship desires. I will
issue
give
fresh
you
notice
by tomorrow.
to respondent numbers 1 to 3 by speed post, fixing a short returnable date. The requisites be filed by tomorrow.
Right.
List this matter.
In the connected matter to
Sorry.
30th September.
In the week commencing 30th September. Connected matter karo 6 and 7. 6 and 7. Same order 6 and 7.
Grateful.
Item number 11.
Your Lordship, I am for the appellant number 2. I am
Appellant number 2.
again all the appellants for all the appellants.
Yes.
I
You are for appellant number 2.
again
Kejon appellant achandi?
I am for the appellants all the
All the appellants, all it. So
I am pressing the IA number 43 of 2024, which is at flag 60 for substitution of appellant number 2, who died on 30/11/2023.
43 of 2024.
Again,
Is it in time?
yes,
It is in time.
yes, ma'am.
All right. IA 43 of 2024. This is an application for substitution of appellant number 2. Appellant number 2, the appellant number 2, who is said to have died on 30/11/2023.
Again,
Others are already on record.
again,
Huh?
again.
Now, okay, Achanti. It is submitted that the right to sue survives against the LRs of the deceased appellant, the details of whom are mentioned in the schedule to the IA. Further, the application for substitution is in time. As such, the application is allowed. क्या करेगा था कौन सा? Consolidated cost that will be filed within 3 days. Whereupon the notice be issued by registered post with AD. Yes. Yes.
My lord, we have already instruction to appear on behalf of all the appellants.
So you have to appear. So no notice needs to be issued.
No,
All right. So say that.
My pardon.
Then counsel for the
In item number 10, sorry.
the counsel for the appellant submits that she has instructions to appear for the LRs of the deceased appellant number 2. Hence, no notice need be issued. Yeah. What are the other applications? For vacation of stay, objection, then miscase no way correction. The miscase जो correction है कर देंगे. So that's all. Has it been admitted? Has the appeal been admitted?
Yes.
So then, who is appearing for the respondents? A.K. Nanda and G.N. Sav. The appeal is otherwise ready for hearing. Is this matter in the week commencing?
30th September.
October.
Commencing 21st October.
24th.
21st October.
In the week commencing 21st October for hearing.
My lord, the interim order maybe.
Interim order to continue.
I may pardon to mention in item number 10, my lord, our names may be deleted because we have already given consent, my lord, in item 10. Mr. Mahadev Mishra and his associates. may be deleted.
Order upload. Number. Kali sir. कौन है तेरा? Already order ही है next week के रास्ते कर दो.
Yes. Item number 17.
Sri P.K. Satpathy, learned counsel for the appellant submits that the brief has. Mr. Ponda, your name may appear. That the brief has been taken away by the client. Office to verify if any other counsel has been engaged. List thereafter. Yes.
Item number 21.
Item 21. Yes, it is your matter. State. 21 कौन उठा पढ़ी ले बता सी.
So that was told in the first clause. You prayed for tomorrow.
Pass. All right, pass.
Item 23. Under order 41 rule 11.
It is my. The present appellant
2013 no matter.
was the plaintiff in the trial court.
Yes, Mr. Mishra.
Present appellant was the plaintiff in the trial court.
Against reversing or confirming?
Reversing.
Reversing.
Reversing that too, a part of that I am challenging. In fact, the lower appellate court has reversed the order of the trial court. The trial. Basically my claim was that a deed of sale executed from one Sukho Dei was fraudulently done in the garb of a power of attorney that was done. I made a prayer in the suit that sale deed be declared as void and inoperative.
On what ground? Fraud.
Fraud. And also for permanent injunction. Restraining the defendants from disturbing my possession. The trial court erroneously held that the sale deed had been duly executed. I preferred appeal. In the lower appellate court has reversed that part of the finding of the trial court. But so far as the prayer of permanent injunction is concerned, the lower appellate court has not addressed that. That is my only grievance. I confine my second appeal to that point only.
All right.
Relief of permanent injunction has not been dealt with.
That is the only ground, Mr. Mishra?
My lord?
Is the only ground?
Yes, that is the only ground.
All right. Third Sri Sashikanta Mishra, learned counsel for the appellant. Appellant, appellants?
Appellant.
Appellant. Peruse the impugned judgments. Considering the submissions and the grounds raised, the second appeal is admitted on the following substantial question of law. Whether the first appellate court was correct in ignoring the relief claimed by the plaintiff of permanent injunction against the defendants while disposing of the first appeal. That's all?
That's all.
You should
So far
notice.
as the other party is concerned, the other party has come in second appeal, another second appeal.
Is LCR necessary? I don't think LCR. Anyway, we'll call for the LCR. You should notice the respondent by registered post with AD returnable within 4 weeks. Requisites be filed within within 3 working days. Raise this matter. They call for the LCR. Raise this matter November.
So we commencing 11th November.
In the week commencing 11th November.
LCR has already been called, scanned. Copy has been received because the other appeal, which the defeated respondents have filed, that is 230. Sorry, 3.
So we'll have to hear both together.
Both are to be taken.
अच्छा ताले इनको करूँ LCR call for जो LCR लाइच लिखूँ तू. It is submitted that the LCR is available in the connected appeal, being RSA number.
RSA 327 by 2013.
327 of 2013. Oh, list this matter in the week commencing
11th November.
11th November along with RSA number.
327 by 2013.
327 of 2013. Yes.
Item 24.
For the appellant doesn't want to prosecute, he has filed an affidavit that he wants to withdraw.
Your Lordship, I am for the respondents. I am in VC, Your Lordship.
I have sought the copy.
No, he wants to withdraw.
Yes, Your Lordship. Only the execution case that is pending, it is since 2015. That may be concluded early. That is only my prayer.
How can I pass that order?
No.
How can I pass that order?
Is it a pending?
This is not your appeal. This is his appeal. He wants to withdraw. Once he withdraws, gone. So you have to proceed before the court below, saying that the case, there is no stay or there is no appeal against it.
This case is disposed of, Your Lordship.
Learned counsel for the appellant files an affidavit sworn by the appellant himself, stating that he does not wish to pursue the second appeal and that he may be permitted to withdraw the same. Permission is granted. The appeal stands dismissed as withdrawn. Yes.
Item 25.
May I please, Your Lordship?
This appeal is against the confirming judgment. The present appellant was the plaintiff and appellant before the lower appellate court. And the respondents were the defendants and the respondents before the lower appellate court.
You are the plaintiff?
Plaintiff.
Suit for?
Suit for partition.
Suit for partition. Yes. Then what happened? It was decreed.
Suit was decreed in respect of the share of the plaintiff number 1, my lord. But in respect of the plaintiff number 2, the purchase land of the plaintiff number 2 was not allowed in favor of plaintiff number 2, my lord. The area purchased by the plaintiff was not allowed in favor of plaintiff.
Okay.
My lord, that area is only 5 decimal. The fact of case is that the plaintiff number 2, who is the wife of plaintiff number 1, purchased an area from one of the co-sharer, my lord. That is an area 5 decimal. By stating that Arjuna is the son of Savitri. And all the co-sharers, all the defendants, except the stranger purchaser, admitting the genealogy of the plaintiff and also stated that Arjuna is the son of Savitri. But the stranger purchaser stated that Arjuna is not the son of Savitri, because the stranger purchaser also purchased an area 5 decimal from this another son of the Savitri.
Yeah, this is a factual aspect.
My lord,
Beyond the factual aspect, why should this?
My lord, both the courts below are stated that though in earlier suit it was decided that Arjuna was the son of Savitri, so that
No.
My lord, if your lordships kindly see the issue.
So where is the genealogy?
My genealogy in lower, my trial court judgment. My
Trial court
lord.
judgment, okay.
Page 6. Page 6, my lord, the genealogy.
Yes.
Initially, Dinabandhu, Uddhava and Kesava. I am belongs to the Kesava branch, my lord. Purchased from the branch of Uddhava, my lord, if your lordships, Uddhava had 2 sons, 3 daughters. Atanga, Madana, Satyabhama, Savitri, Parvati and Kausalya. This is the dispute, Savitri, my lord. Savitri has 2 sons, Arjuna and Hari. Arjuna's son, Abhimanyu and Hemalata, sold the property to the plaintiff number 2. But as per the stranger purchaser, Arjuna is not the son of Savitri. Hari is the only son of the Savitri, and it has been already decided by the previous suit, my lord. And on that issue, the issue was framed whether Arjuna is the son of Savitri or not. And the trial court, as well as both the appellate court, has stated that previously it was decided that
Arjuna. I am asking what is wrong in this finding?
My lord, if your lordships kindly see, that judgment also exhibited, my lord. Exhibit 1, my lord. And in that judgment, my lord, that was not decided. It was decided in that suit that whether Savitri was the son of Ghana or not. That is the only, in that suit, it was decided. Whether Arjuna was not, whether son or not, that was not decided in that suit. If your lordships place me that earlier suit, my lord, that issue is in that suit, my lord.
Let us see where the trial court has dealt with this previous suit.
My lord, issue number 3. Is the plain genealogy correct and is Arjuna son of Savitri?
So the finding the footage.
My lord, the finding is that my lord, 16, my lord, page 16.
Yes.
The correctness of the genealogy furnished by the plaintiff is under challenge by the defendant number 9 to 12, 18 to 20, 23, 27. The genealogy of the concerned parties have been given under the schedule of the plaint. The onus lies on the plaintiff to prove that genealogy is correct. Admittedly, no documentary evidence is on this point. PW1 in his evidence has stated that genealogy furnished in this case is correct. It is further stated that his father had also filed title suit number such and such, and in that suit, the same genealogy had also been furnished. DW1, Parikita Panda, who himself is defendant number 2, has also stated that same fact. Bhaskar Ponda, who has been examined as DW1 on behalf of defendant number 18 to 20, my stranger purchaser, has stated that the genealogy furnished by the plaintiff is wrong. It is specifically stated that Arjuna is not the son of Savitri. The only son of Savitri is Hare Krishna and Gopinatha is the father of said Hare Krishna. It is also revealed from his evidence that Arjuna is not the member of his family, and this fact has been finally adjudicated upon in the judgment passed in CS number 22763 and title appeal number 26 of 64. Exhibit 1 and 2 are respective certified copy of the judgment of the above suit and appeal. It is revealed from the said document Exhibit 1 that Savitri has only son Hari alias Hare Krishna, who was the defendant number 1 in CS number 275 of 63. It has also been held that said suit belongs to Manika, Lavanya and Savitri, etc. developed on Hari alias Hare Krishna. The Learned Counsel for defendant number 9 to 12 and 18 to 20 has fairly submitted that earlier suit has filed between the said parties and for the same subject matter. The finding of the said point by the Learned Munshi Bhadrak has also not been set aside in the appeal. There is no second appeal preferred against the said judgment of the lower court, and as such, it is binding on the parties.
He has entirely relied on the previous judgment. Judgment is the previous suit.
My lord.
So what is wrong with it?
My lord, in the previous suit, it was not.
Let us see the previous judgment. Yeah, what is the genealogy?
My lord, they have not mentioned the genealogy in that judgment. Only issue number 4.
Basically, the plain genealogy is not correct. According to them, Dinabandhu was the eldest son of Ramakrishna and Govinda, and Gana. Dinabandhu is the eldest son of Ramakrishna and not Govinda. And Gana has 4 daughters. ঘন কোটা আসলে
My lord, ঘন হলে
এটি তো জেনোলজির নাহি ঘনর না namely Satyabhama, Savitri, Parvati and Kausalya, and Kamala had no daughter namely Savitri. But I'm inclined to believe that Satyabhama, Savitri, Parvati and Kausalya were the daughters of Ghana
my lord,
and sisters of Madan and
Ottanga. My lord.
So, who is here? Ghana has not been mentioned.
My lord, not mentioned, but if your lordships kindly see the aberment taken in the plan, my lord, in the judgment, it is reflected that in page 3, my lord, in the trial court judgment, that as such, Dinabandhu, sorry, I'm placing there also that said Dinabandhu and his son Darshana were separated from Uddhava and Kesava in mess and property by meets and bounds after the revision settlement. In such, Dinabandhu and his successor have no right title possession over the suit land.
So, Ghana is the son of whom? The Ramakrishna Pandit?
No, my lord, Uddhava. Uddhava and
Uddhava, the second son.
My lord, Uddhava.
There could mention any year mention any?
Genealogy mention karnadi. But in the
so they have said that Uddhava, according to you, Ghana is the son of Uddhava. So that makes Savitri the granddaughter of Uddhava. Isn't it? But here there is something else.
No, Savitri is the daughter of
Ghana pura?
Ghana.
Ghana ଯଦି ଉଦ୍ଧବର ପୁଅ ହେଲା ତାହେଲେ ତା ନାତୁଣୀ ହେଲା ତ ଏଇଟା ଫାଇଣ୍ଡିଂ ଟା ଟିକେ so the genealogy which you have given is not correct.
No, I have taken such plea, my lord, in 80 days.
I have nature କିନ୍ତୁ theory କଲା ବେଳକୁ ସେ ଭୁଲ କରିଛନ୍ତି.
That has not been. But in my plan, my lord, I have taken.
Okay.
Sethi decide hela Savitri, whether Savitri is the daughter of Ghanna or not.
Here the question is whether Arjuna is the son of
Savitri.
That has not been decided yet.
That is, and all the co-sharers.
Third Sri S.K. Naik, learned counsel for the appellant. Appellants.
My lord, appellants.
Appellants. Here is the impugned judgment. Considering the submissions and the grounds raised, the second appeal is admitted on the following substantial question of law. Whether both the courts below were correct in relying upon the judgment passed in TS number 275 of 1963 relating to the finding that Arjuna is the son of Savitri, even though the relationship of Arjuna and Savitri was not the subject matter of the said suit. Issue notice to the respondents by registered post, returnable within 4 weeks, requisites be filed within 3 working days. Call for the LCR. Is this matter?
18th November.
18th November. Ito kon IE file is?
Let's say the date already allowed.
Limitation allowed. Baki? Abatement so
Substitution. I have already filed the consultation.
All right. Is this matter in the week commencing?
18th November.
18th November.
Obliged.
Item number 26.
Next. Next week.
Bill memo mobile kichi nahi copy notice भी receive नहीं हुआ
नहीं नो इटा एडमिशन टा आसी नोटिस जाई न थो
हाँ
एडमिट ही नहीं अपन सोमोटा अपेयर करछन
appeal memo
Is this matter in the week commencing 2nd September? वो तो एडमिट होगा ना होगा अपन कभी नहीं कहो बोलिए एडमिट तो ना कभी unless you have some professional reasons. Next week as paid for, but 9th September. We commencing 9th September. Yes.
Item 28.
No, say the reversing judgment. Plaintiff's suit is dismissed. Appeal is prepared. It was reversing of the suit for. It's a suit for declaration of right title interest, confirmation of possession, and for formality election. Well, here the plaintiff's case is this: that one Uddi Sahu and Bauri Sahu was the original recorded tenant of the suit property. They sold this property to the father and uncle of plaintiffs. Then plaintiff's father and uncle, they divided this property, and subsequently uncle's share was also purchased by the plaintiffs. So in view of this purchase, right now the plaintiffs became the absolute owner of the entire suit property. Defendant stated that they have purchased this property from the original recorded tenant. What I find is that the first appellate court judgment is not available. The trial court judgment, 3 copies of the trial court judgment have been scanned. देख लो बाबू फाइल फिजिकल फाइल बाहर करो हाँ तीनटा पर अच्छा 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 तीनटा सेही सेम डॉक्यूमेंट को सेम जजमेंट को तीन थर स्कैन ହେଇଛି तापर ଯାଇକି फर्स्ट appellate court and the London trial court came to a conclusion that this suit property is not identifiable. The planned schedule land which is given in the document itself, means I mean to say in the sale deed itself, is not properly identifiable. Its boundary which is mentioned in the planned schedule, that is also not matching to the sale deed. So this, even if decree is passed, this cannot be executed against the defendant because it's a confirmation of possession and for permanent injunction. Why did you take 26(9)? My lord, yes, that of course, my lord, I am coming to this. My lord, I am not plaintiff. I am the defendant before the London trial court. Then, but I thought you said the suit was dismissed and confirmed by the appellate court. No, not confirmed. It was reversed. We were the defendants of the trial court. The London lower appellate court, my lord, he came to a conclusion. Even if the planned schedule is not identifiable, even if the decree cannot be executed, still then it can be executed in the event plaintiff file an application for execution and he could have approached the concerned executing court to execute the decree by correcting the plot numbers if it is not matching with the planned schedule. My humble submission before your lordship, the only substantial question of law remains here. Well, whether SK Samantrayal counsel for the appellants peruse the impugned judgments, considering the submissions on the ground says the appeal is admitted on the following substantial question of law. A para page 8 se quote korchanti A hela seti khali kodre hela. Notice need not be issued, probably you have appealed. He has appealed.
You will also have appearing for the
All the respondents?
number. No, only for respondent number 1.
Only for respondent number. So notice has to go. Your good name, sir?
Manoj Kumar Agarwal.
Manoj. Sri Manoj Kumar Agarwal. As Sri Manoj Kumar Agarwal has entered appearance for respondent number 1, no notice need be issued to him. A copy of the appeal memo will be served upon him. Issue notice on the other respondents by registered post, returnable within 4 weeks, requisites within 3 working days. List this matter in a call for the LCR. List this matter.
The week commencing 18th November.
The week commencing 18th November. Yes.
I think 29. Okay. The appeal carried an appeal passed by the Lord Civil Judge Senior Judge Podola in a matrimonial dispute. And the appeal, when the appeal was pending, the same was dismissed on order dated 8/9/2022, running by 17 Lordship.
No, this is an application. This is about discharge Ganjam. How can the discharge Ganjam take over when I take note of this, take cognizance of this matter? When there's a family judge there?
Plus now, both the judges have lots of power, lots of in matter also. Another case also.
District court has power. District has power.
There was a liberty was in paragraph 5 Lordship. Liberty was granted to prefer an appeal. In one case,
the original, the trial was by the senior civil judge.
Lordship.
Okay. So you got liberty to prefer appeal.
Lordship. Lordship, the appeal was dismissed on the ground of a delay of 48 days, Lordship. The petition to prefer an application for restoration the same was rejected on 13/4/2024, running by 20 Lordship.
There was initially it was filed, it was dismissed for default.
Lordship.
Then it was restored. Restoration application was
rejected.
All right. I'd say SK Mantil and counsel with the appellant. Considering the submissions, and the grounds raised, I will peruse the improved judgments. Considering the submissions and the grounds raised, the second appeal is admitted on the following substantial questions of law. Koda, Oliver? A will not do.
Yes.
paragraph 9 of your appeal. Because we will not be entertaining that question, whether the civil court had jurisdiction or not.
In fact, in the
Simply that delay part. Whether the first appellate court was correct in rejecting the petition for rejection, for restoration of the appeal on the ground of delay, despite the same being explained adequately. Issue notice by speed post, fixing a short returnable date, requisites shall be filed by tomorrow. Please this matter. Notice please this matter. Short date.
21st October.
No, September.
30th.
Please this matter in the week commencing 30th September.
Okay. I don't know 30.
In this case, the plaintiff purchased 150 land from one co-sharer out of 4 co-sharers. The defendant purchased 4 share from 4 co-sharers. There are 5 co-sharers. But in the consolidation operation, the defendant purchasers recorded entire land in their name. Thereafter, the petitioner the appellant moved before the consolidation authority by filing objection case that 1/5 share purchased by him has to be recorded in them. But the consolidation simultaneously, he has filed a suit before the trial court seeking declaration of right title interest, and there is an allegation of a forgery in execution of sale deed in favor of the defendant. And such allegation, another point has been raised that the SCO who passed the order for recording of the land is beyond the jurisdiction. As per section 11, if the SCO found that all parties interested agreed for recording of the land, he has to record the land, or otherwise he has to refer that to the consolidation of it. These 2 grounds fall for consideration before the civil court. The civil court dismissed the suit, observing that since the consolidation ROR has been published and that attained finality, civil court has no jurisdiction. Consolidation revisional authority hold, since you have approached the civil court, your grievance has to be considered before the civil court. Thereafter, the plaintiff.
But statutorily, there is a bar for the civil court to take cognizance once the consolidation notification has been issued.
There is a little scope with such principle. If there is an allegation of fraud or perjury or any jurisdictional issue, the civil court can examine the same.
Do you have a copy of your plaint?
I have the copy of the plaint.
Please. I think fraud can also be considered by the consolidation
authority. Consolidation authority dispose of the revision, holding the suit is pending. Thereafter, that order assailed before this court.
The ODA plaint.
Again, this court, when the consider the issue of validity of the revisional court order, observe, you raise all the issues in the pending appeal. That I have quoted at page 9 of this.
Court लिखाई देख ले. Court लिखाई तो देख ले. तो बाहर कर ले.
जो फर्दर विषय
चंचकता करी से नहीं गले भी लिखाई थी देखो. सुवाटा लिखाई थी.
एक पैरा लिख.
What is it?
2%. लिखा है 1984 मसीह गौरचंद्र महापात्र उग्र मान विवादी नाम जो कबला कर उक्त कबलार आम्भे बादी बाइया चौधरी नित्यानंद सामंतराय महापात्र साक्षी भाव दस्खत कर दाबी शाबक खसड़ा मानकर चौधरी नित्यानंद सामंतराय महापात्र कौन सत्य
ଲଭ ଅଂଶ ନଥିବାର ସ୍ୱୀକାର କରିଛି। ମାତ୍ର ଆମ୍ଭେ ଦାବି ଏପରି ଭାବେ ଜାଣିବାକୁ ପାଉଅଛୁ ଯେ ବିବାଦୀ ମାନଙ୍କ ନାମିତ କବଲା ସମ୍ପୂର୍ଣ୍ଣ ଅବୈଧ ବେଆଇନ କବଲା ଅଟେ। ତତ୍ସ୍ଥଳେ କୌଣସି ଦଶମ ଟଙ୍କା ଆଦାନ ପ୍ରଦାନ ହୋଇନାହିଁ। ଉକ୍ତ କବଲାରେ ଆମ୍ଭ ବାୟା ଚୌଧୁରୀ ନିତ୍ୟାନନ୍ଦ ସାମନ୍ତରାୟ ମହାପାତ୍ର ସାକ୍ଷୀ ଭାବେ ଦସ୍ତଖତ କରିନାହାନ୍ତି। ଆମ୍ଭେ ଶ୍ରଦ୍ଧା କରୁ କି କୌଶଳୀ ବିବାଦୀ ମାନେ ମଧ୍ୟ ଅନ୍ୟ କୌଣସି ବ୍ୟକ୍ତିକୁ ଚୌଧୁରୀ ନିତ୍ୟାନନ୍ଦ ସାମନ୍ତରାୟ ମହାପାତ୍ର ବୋଲି ଦର୍ଶାଇ ଉକ୍ତ କବଲାରେ ନିତ୍ୟାନନ୍ଦ ମହାପାତ୍ର ବୋଲି ଦସ୍ତଖତ କରାଇ ନେଇଅଛନ୍ତି। ଆମ୍ଭେ ବାଦୀଙ୍କର ବାୟା ନାମ ଦସ୍ତଖତ ବିଭିନ୍ନ ସମୟରେ ଚୌଧୁରୀ ନିତ୍ୟାନନ୍ଦ ସାମନ୍ତରାୟ ମହାପାତ୍ର ଭାବେ ଦସ୍ତଖତ କରିଅଛନ୍ତି। ନିତ୍ୟାନନ୍ଦ ମହାପାତ୍ର ଭାବେ ଦସ୍ତଖତ କରନ୍ତି ନାହିଁ। ତେଣୁ ବିବାଦୀ ମାନଙ୍କ କବଲାରେ ଆମ୍ଭେ ବାଦୀଙ୍କର ବାୟା ଦସ୍ତଖତ କରିନାହାନ୍ତି। ବିବାଦୀ ମାନଙ୍କ କବଲାରେ ନିତ୍ୟାନନ୍ଦ ମହାପାତ୍ର ବୋଲି ଯାହା ଦସ୍ତଖତ ହୋଇଛି ଉକ୍ତ ଦସ୍ତଖତ ଆମ୍ଭ ବାଦୀଙ୍କ ବାୟାଙ୍କର ଦସ୍ତଖତ ନୁହେଁ। ଉକ୍ତ ଦସ୍ତଖତ ସମ୍ପୂର୍ଣ୍ଣ ଜାଲ ଦସ୍ତଖତ ଅଟେ। ବିବାଦୀ ମାନଙ୍କ ନାମିତ 1984 ମସିହା କବଲା ମୂଳେ ବାଦୀଙ୍କର ବାୟା ଚୌଧୁରୀ ନିତ୍ୟାନନ୍ଦ ସାମନ୍ତ ମହାପାତ୍ରଙ୍କର ଦାବି ଅଂଶ ଲୋପ ହୋଇନାହିଁ ଏବଂ ଆମ୍ଭ ବାଦୀଙ୍କର ବାୟା ଦାବି ସମସ୍ତ ଭାବରେ ଖସଡ଼ାରେ ତାଙ୍କର ଅଂଶବୃତ୍ତି ଦାବି ପକ୍ଷେ ସମ୍ପୂର୍ଣ୍ଣ ଭାବେ ମାଲିକ ସତ୍ତ୍ୱାନ ଦାଖଲ ଅଛି। signature signature ଟା ଯେହେତୁ
So what did the first appellate court hold?
First appellate court same reiterated the view of the trial court holding that since 51 is bar, the suit is not maintainable. But when the revisional order was challenged before this writ petition, both the parties agreed that all the points has to be taken note by the appellate court. That is page 9 of the order টা quote କରିଛି। ସମସ୍ତ ଗୋଟେ କେସ୍ ଡିସାଇଡ୍ ହେବାକୁ ଏଗ୍ରି ହେଇଗଲେ ତାପରେ ସେଠି ଗଲା ପରେ ମାନେ
Page କେତେ?
page 9 of second appeal memo.
Order passed by this court?
Order passed by this court. First, learned counsel for the parties in course of submission statement made at the bar that involving the selection issue, there is already civil proceeding pending, title appeal number 9 of 2002, pending in the additional decision of Bhadrak. Even though the writ petition is filed on so many grounds involving the impugned order or annexure 1, this court finds substance in the submission of both the counsel that ultimately the order by the annexure 1 shall remain bound by the judgment and decree to be passed by the civil court.
They have relegated you to the title appeal.
Or the questions and contents has to be raised.
All right. Let's see the Satpathy, learned counsel for the appellant, peruse the impugned judgments. Considering the submissions and the grounds raised, the second appeal is admitted on the following substantial questions of law. Page 13 row I. Idita.
Again. Again.
Idita, it will cover it.
Again, okay.
If you notice, the respondents by register of post returnable within 4 weeks, requisites be filed within 3 working days. LCR be called for. LCR may not be necessary, but let LCR be called for. List this matter in the week commencing
25th November.
25th November. Tomorrow we'll take up hearing matters. Pathar ठीक ଅଛି pathar ସରିଲା ପରେ hearing matters.
Thank you.